Yes, please.
Beg lordships, pardon, my lords. My lords, item.
Let your senior start. Yes.
Item number 14. On behalf of Mr. Patnaik, Hadouki of May 13 or 14 any date your lordship fix. Already he has mentioned.
Yes, he mentioned. Mr. R.K. Samal.
Huh.
You have power here, Mr. Samal?
I have already left the.
R.K. Samal, Santosh Kumar. Anyone present for the other side?
No, I will inform. Mr. Nanda, I will inform.
You want?
13 or 14 any day.
14-5.
Again.
The order will be passed when the matter reaches. Okay, noted. Yes, next.
My lord, item 15.
1-5, yes.
My lord. Can you take up after vacation, my lord?
Yes, your lordship.
Anyone present for the petitioner?
I am
For
for
the
the
petition, your lordship, I also need to file the rejoinder in this matter.
15, Mr. Samir Das.
Pardon,
my lord, who's that?
item 10.
I'm for
Mr. P.K. Behra. P.K. Behra. When do you agree for a date?
My lord,
Yes, sir.
Mr. Behra and Mr. Misra?
yes, sir.
After vacation, ma'am.
Date karantu.
24.
24 on consent. Yes, next.
Obliged, my lord.
Item 29 on lordship's board, my lords.
29.
My lords. I've already intimated the other side, my lords. My
You are
lord,
Mr.
SS Patnaik.
S.S. Patnaik.
My lords.
You have informed whom?
For petitioner, Pratik Das, my lords.
Okay. Anyone present? In item 29, you are present, sir? Kebe chahunchoti?
Lords,
Mr. Patnaik,
after vacation, my lords.
after vacation, they have to date.
My lord, item 7.
Yes, next.
Item 7. Item 7, I am for the OP. Notice for yesterday. my-
Orders matter, please don't mention.
Well, item
You
22.
must understand that orders matters are listed for orders, not to be adjourned.
Well, item
And
22.
after notice matter without consent and specifically adjourned will not be adjourned. Please wait, or if you are leaving the court, don't turn after mentioning, don't turn around to that side. Mahatma watches us silently and very depressed. He looks at times depressed also.
My lord, your lordship.
My lord,
Come on, my shade.
no. I could not hear you. My lord, your lordship.
Your lordship, after when it will reach, I will mention it. When your lordship advised me to mention when it will reach. That's why.
No. I never completed the sentence.
Right.
When you turned around, I just continued. Your learned colleague. I never advise. Most important part of the advice that if you are leaving the court, inform your learned colleagues for the date.
22, my lord.
When do you want this? When do you want? You are Mr.
My lord,
Item.
item 7. Actually, I received notice yesterday, my lord. So
You are for the respondent.
my lord,
Then please don't do this.
my lord, I received notice.
Don't get confused while mentioning. You are not on record. Your presence is yet to be marked. ଆପଣ ଆସିକି
No, sir, kindly, I mean,
look at the list.
I
List to have some substance in your argument.
22, my lord.
ଆପଣଙ୍କ ନାଁଟା କଣ? Sorry, ମୁଁ ଭୁଲି please don't mind.
Ramachandra Jana.
Since Prabhas Chandra is the petitioner, you have been selected. Ramachandra, yes.
22, my lord. I am appearing for the petitioner. In the case, rejoinder affidavit has filed, but not yet tagged in the case records. So, let it come after 1 week along with the rejoinder affidavit.
Kindly repeat your submission, sir.
My lord, affidavit has already been filed.
22.
22.
So, Prafulla Mahapatra.
Yes, rejoinder affidavit filed, but not
When did you file the rejoinder?
rejoinder, my lord. Data.
Sir, how the court will know? When you do not know when you filed the rejoinder, how the court will know?
After 1 week as well. If
you...
Data ke मन नहीं.
Highly sir. How can it be recorded then?
Yes, sir.
Your feelings.
Simply, you will see.
I'll innovate something. I'll say that you feel that it has been filed. Feel like today's temperature, it feels like 41. Actually, it's 37. Mr. Since you are mentioning making a special thing, I'll dictate this. Order item 22. Who is in 22?
State, opposite party.
Opposite party, but they have a panel. Mr. P.K. Mahapatra for the petitioner.
22 Prabhu Tamar.
Mr. Prabhu is there. Prabhu, do you know when it has been filed? Rejoinder.
Agenda.
You see, Prabhu doesn't know. Then how the court will know? Mr. Prabhu Prasanna Behra, Additional Standing Counsel for the state. It is submitted by the learned counsel for the petitioner that he feels that the rejoinder has been filed. And the matter, since though it is felt that the rejoinder has been filed, the same has not been
Not the decision.
attached to the brief, attached with the brief. How much time, sir?
After one. After
Are
one.
you sure your feeling will fructify into something?
नहीं फाइल I'm a petitioner though, bro. Petitioner I'm a.
I can't record that. Then have to record that. Though he has filed, he doesn't know the date. So that I'm avoiding actually. To get over that, this kind of order. This date कोटे कौन आंती?
May 14. Second week.
14/5.
I may be served with a copy, Manus. Copy is also not there with us.
He still
I may
feels.
request-
He may feel to file survey a copy.
My lords, Ajay.
He may think. Sorry, he may think to survey copy.
I may request my senior.
The learned counsel for the petitioner may have a copy of the rejoinder which he feels to have been filed as requested by the learned ASC.
Yes.
Item 22. Yes. Yes, please. Next.
Your Lordship,
Mr. Sekhar,
item 10, Your Lordship.
110.
10. On last occasion on 7/4/2025, I was served with a copy of the counter affidavit. So therefore, I pray for some time to file the rejoinder, Your Lordship.
Don't have power.
No, Your Lordship, I
Social
don't have
15
power.
minutes. Who, sir? Mr. Patnaik? Here comes.
My lord,
This is for?
I am for the petitioner, Your Lordship.
I understand, but it shows
On
Santosh
behalf
Kumar
of,
Patnaik.
On behalf of SK Samal, Your Lordship. He's for the appearing for the.
No,
other
I
opposite
understand,
party.
sir. I understand. Who has served?
Mr. Swain.
Mr. Prabhu has served or
Mr. Swain.
Swain, Sanjeev Swain? That is that you have received counter in the writ petition,
My lord.
but it's why it shows it is a OFDC. Why Mr. Senior Mr. Patnaik's name is there?
OFDC is a party, Your
अच्छा,
Lordship.
ठीक है.
And one more
Date
matter.
केबे कहले? When will suggest a date?
After vacation, Your Lordship.
तो date कर दियो.
24/6.
But the order will be passed after somebody is in presence of OFDC.
My lord. And another matter, Your Lordship, item 30.
1-3.
1-3. Appearing for the husband petitioning, Your Lordship, in this matter.
1-3 is Alok versus state.
3-0, Your Lordship. 3-0.
I'm so sorry. 3-0.
My lord.
Yes.
I pray this matter will be taken up 1 week after, Your Lordship.
Date.
1 week after.
Kindly give a date.
13/5.
13/5.
Interim order to continue.
If any counsel appears, then he has to be recorded.
My lord.
Like the other matter was mentioned by
No,
Mr.
but nobody has appeared
Ramachandra.
for the other side, Your Lordship, in this matter.
Could be, but that's the noting. But Ramachandra has already appeared.
My lord.
Yes.
There's an interim order that may continue.
Yes. Yes.
Grateful, my lord.
Yes.
I may be pardoned to mention a matter.
Please.
Item 18 of the list.
1-8, sir.
I have not taken the kind of the advocate of the petitioner because I could not find, because I have a
Santosh Nanda is for the opposite party.
what
You take consent from whom?
I have to take consent from the petitioner advocate.
Why? For appearing for the opposite party?
No. I am praying for an adjournment because I got a bar achi to.
No, I'm not
Mamu
getting, sir. I am not getting you. You are appearing for the petitioner or the opposite party?
Opposite party for the bank.
Acha, you are saying that for adjournment.
Yes. And a mamu
Oh, that's really nice of you. You are thinking about the petitioner.
No,
Good,
kali
good.
podna jo din
I could not believe your submission. That's, I thought that
But
you are thinking.
as you got a-
Okay, you wanted date 18th? Dates are suggested. I'm sorry, item 18 date.
आज का problem और अच्छी
No. Any date I am not, any date is not there.
I
actually.
have to
Any date, my lord, please, I have been watching the calendar. I don't find any such date. Any date. It starts with 28, ends at, say, 3rd May.
minute.
Starts with 29, ends with 3rd May. 29th April.
ये लड़से में फर्स्ट ऑफ में
Yes, I mean that those are only the dates. Those
फर्स्ट ऑफ में will do because
4, 5, 9, 3, 12. 12टा दिन ଅଛି ତା ଭିତରୁ ଯୋଉଟା କହିବେ।
ମୋର ଆଜି ଗୋଟେ ପ୍ରୋବ୍ଲେମ ଅଛି
5 sorry।
पर्सनल डिफिकल्टी
नहीं, I could not get the date, sir।
5 तारीख
पाँच-
5 तारीख हमरो सोमवार हबनी सोमवार टे
Please give way, sir, give it a date। I have no fascination for Monday।
1 तारीख 1 की 2 नले
1-5
8 हां 8 है 8
1-5 ठीक है।
8 हां पर्सनल
If Mr. Ponda says for another
ମୁଁ
date,
କହି ଦଉଛ ଆଜି
no,
ମୋର
kindly accommodate him।
हां हां ମୁଁ କହି
Since yes, Mr. Ponda was present yesterday, so he may come today. But, I mean, he may
ମୁଁ ଟା
say
କରି କହି ଦଉଛ ମୋର ଗୋଟେ
no,
पर्सनल
regarding date.
हां
Whatever date he suggests, I will give।
yes,
Yes,
yeah,
next,
I will accommodate but
Yes, yes.
not on 5th 5th I am
Yes।
Milord, this matter has been posted in 11/4/2025.
Which one, sir?
Milord,
Out of list.
Milord, it is WPC 1670, not in today's list.
List ଅଛି ନା, not today's list।
Not today's.
You want what?
Milord, it is listed in 11th April 2025, but at that day I cannot appear. But as I have tried to appear to virtual mode in virtual code of
11/4 before this bench।
Milord. 11th April 2025 रे posted ହେଇଥିଲା. I cannot appear on that day.
नहीं, assignment ଟା କଣ?
Assignment is a
Subject matter roster କଣ ସେଟା?
so this family matter. It is
11/4 I was having this assignment। Or like
Double-
some it is a writ petition।
Milord.
Oh,
Milord-
some writ petitions। ସବୁ all matters you asked। So I can send it to the registry for listing। You are sure? Confident?
Milord.
List कर दियो। He says that there it was adjourned। date केबे दिया ହେଇଥିଲା?
Milord, it is in order. It is stated that the counsel of the petitioner should mention in this bench. Then,
अच्छा, liberty to mention for listing before the assigned bench। Now you are saying this is the assigned bench। So very well। ନିଅନ୍ତୁ କୋଡେ ଆପଣଙ୍କ ଲୋକ ତ ନାହାନ୍ତି କେହି ମେମୋ ନବା ପାଇଁ।
Pardon to mention, my lord.
ମେମୋ ମେନସନ ମେମୋ
Mention.
ଆସାଇନମେଣ୍ଟ ଅଛି ତ
Yes.
ଦିଅନ୍ତୁ ଦେଇ ଦିଅନ୍ତୁ।
I am pardon again 14ଟା ଆପଣ 5 କୁ କରିଛନ୍ତି ମୁଁ 5 କୁ ରହୁନି 14ଟା 5 ତାରିଖ କୁ କରିଛନ୍ତି ମୁଁ ସିଏ ମତେ କହିଛନ୍ତି ମୁଁ 5 ତାରିଖ ମୁଁ ଟିକେ
5 ହେଇନି 14ଟା ହେଇଛି 14/5। ଇଟ୍ସ ନଟ୍ ଦ୍ୟାଟ୍ 14 ହେଇଛି 5 ବୁଝିପାରିଲେ।
Pardon to make a mention, my
Please.
lord. Item number 39.
39
39, my lord. I am on behalf of Mr. Patnaik, my lord, for respondent number 3. My lord, I have intimated, I have
So Amit
requested.
Patnaik,
Amit
My lord,
Patnaik,
in
sir.
this matter, on my
Lord,
mention,
I have
Mr.
requested
you are
Mr.
Mr. P. Das।
My lord, P. Das, my lord, on behalf of Mr.
Yes, yes.
Amit Patnaik. My lord, I have
Respondent three.
requested Mr. Jena.
Jena
He is
is-
there. My lord, I have requested and on, my lord, mutual agreement.
Here is there।
My lord,
on,
my lord, he is there.
on my request, it has been listed today. Let it because Mr. Senior Advocate, Mr. Sushant Das is out of station. That's why he has given his consent that for listing of the matter on 6th or 7th. Any date you not select.
6th of,
or 7th, May.
6th of May, my lord.
6th of May।
We are,
Mr. Jena is 6th of May।
Yes, my lord. Yes, my lord.
On consent 6th of। Yes, please। Next।
obliged.
Supplemental list, item 1.
I may please. I am for Krishna Chandra Das, the petitioner in TRP 9224.
So the first one is Sabita Rani।
And the white.
So
So his TRP
can you settle the dispute of taking up of the matter for the or first matter or the second matter?
as you lordship,
No, I don't, please. It is these are two warring factions. So the coincidence, it is not intended that the wife's matter is taken up for listed fast.
Not wife. I am filing the.
You are talking about your wife or Krishna
No
Prasad
wife.
Das?
No wife.
No, you are talking about you are married.
I am married.
I mean, I am talking about Mr. Niranjan. You are Mr. Niranjan Raut.
Yes, my lord.
Are you married?
Nani,
In person, you are married.
the petitioner.
No, you, Niranjan
I
Raut.
am married.
Then why you are saying not wife, not wife? I don't understand.
The-
You are in live YouTube.
No, my lord.
It's just possible that your wife will be watching.
No.
So when you start
The document I have annexed.
out of turn, when you start blabbering in a court, not wife, don't do that.
He is submitting that he is the wife.
He's submitting his petition. Please wait for your turn.
Yes, I am sir.
I believe that both the warring factions have agreed for today's list of the court.
My lord.
Because his matter is fast, let him submit. So you will have your chance. And in between, suddenly don't say not wife, not wife.
I am filing a counter and a power, my power.
Don't interject the learned counsel.
My lord.
I'll record that you are interjecting.
My lord.
Don't identify yourself with Krishna Prasad Das. Remain a lawyer, officer of the court. Stand tall. Are you following me?
My lord. But I am.
Never identify with any client. Enter the court. You are wearing your robes. Never identify. Be patient.
Yes,
be
my
confident.
lord.
Yes.
May I please, your lordship? Present petitioner is the wife of the opposite party number 2. Opposite party number 2.
Yes.
Opposite party number 2 suppressing
How
his.
many wives and husbands are parties to?
Here, my lord, what I submit.
You see,
by suppressing his earlier marriage, having 2 children.
sir, please answer the question.
Yes, sir.
How many wives and husbands have been narrated as parties in the petition?
I am the only wife. Srimati Sabita Rani Behra is the wife of the Krishna Prasad Das, who is the opposite party 2 in my TRP 109 2024. Petitioner is the
20?
109 of 2024. TRP CL number.
24 रे BNSS आस जाइते लगी. अच्छा, से जो जुलाई पर आसी गला.
आ गया.
This is a but 407 CRPC तो इटा BNSS हवनी. पुराना केस उड़ा का BNSS हवनी. It's an alternative नहीं. The law is clear that you have to, though you have maybe mentioned that, but
one affair was lost at the relevant time. CRPC was, but when this petition come, BNSS, so I alternative to say provision mentioned.
criminal law alternate provision not hai. There is no ex post facto law. Have you read the constitutional provision? Which is ex post facto law? Bar against ex post facto law? Which article?
Article 20 of.
Sorry?
Article 20 of.
Excellent. 22 most likely. 22(5). So that perhaps that is the reason the new law cannot be sought for.
No, one affair at loss.
I am on a preliminary issue that whether I should mention BNSS or CRPC.
We mention both. 407 CRPC reduced section 447 of BNSS.
20. Excellent. 20. It's not 22. 20. 22(5) is here. You are saying that you married OP number 2?
My lord.
The notices have been issued to all.
My lord. OP number 2, suppressing his early marriage, he contacted with.
No, you don't have to argue again because already the coordinate bench has passed orders issuing notice or what?
Coordinate bench passed. The both the matters should be heard analogously.
ठीक अछि. So that is not modified yet.
So my.
Mr. Raut, you are Mr. Niranjan Raut.
My lord.
So
I am appearing.
So definitely, sir, I don't doubt you. But have you filed your wakalatnama?
I am filed.
Here there is no facility of filing it.
I will file it
with Mr. Niranjan. Mr. TRPCRL lekhiyo 109 of 20. Don't get confused. Apano etere confused. Etere prabhavito hontu nahi. Apano you keep your concentration. TRP CRL 109 of 2024. Mr. Tapan Kumar Mahanti for the petitioner. Opposite party blank. Blank, no, sorry, Mr. Devraj Mahanti. Devraj Mahanti, AGA, Mr. Sanjeev Swai, AGA for OP number 1. Para. The learned counsel for the petitioner refers to the earlier orders passed by the coordinate benches, coordinate roster benches, assigned benches, particularly order number 3, to that he has served a copy of the petition on the learned counsel, Mr. Niranjan Raut, for the opposite party. Mr. Raut is present in court, submits that he shall file his wakalatnama today in the registry. The wakalatnama shall be kept on record, taken on record, scanned copy be updated. Scanned copy be updated. Yes.
My lord.
The next petition ne kaun hela situation?
My lord. Both the
Acha sunantu. Acha, since you are yet to appear, after you appear, then
I am also filing the counter affidavit.
no, before appearing in a matter, you are not authorized to file counter also.
Well.
Whatever pleadings you are free to appear, no problem. Pleadings has no issues actually. It is submitted by the learned counsel, Mr. Raut, that he shall file his file. He shall file counter on behalf of the OP number 2. Kodino file kariye?
Today.
Shall file in the OP number 2 after the same shall be accepted upon service of copy thereof. Unless you serve copy, it will not be accepted.
Already served.
Copy has been served. Copy kati lekhantu.
The state also.
Lekhantu. Copy of the said counter has been served on the learned AGA for OP1 and the learned counsel appearing for the petitioner. The counter shall be taken on records, be updated. Yes. Next matter, the TRPCRL 92, the order as the notice is sufficient, appearance is complete.
My lord.
I may prayer lordship.
This is the spirit. The counsel for the, you are for the wife or husband?
I am the wife.
Wife is assisting you. That should be the spirit between the, especially when you are appearing for husband and wife.
I may prayer lordship.
Just as he definitely, sir.
In the interim.
Please wait, sir. Please wait. Little bit time, sir. Yes, appearance is complete. Yes. Please.
Well, the interim order which were allowed, that has been discontinued. Maybe continued.
The next date, it is not discontinued. If there is no hearing, no other order discontinuing express old High Court of Justice L. Mahapatra prior to that Allahabad High Court, unless the judicial forum expressly modifies the order, there can't be presumption of discontinuance. Our High Court, Allahabad High Court.
Oblige.
So that's strictly speaking, I think that's the correct view.
Well,
because if 100 matters are listed, somebody will say that it is discontinued.
So it is pending.
Correct. It is submitted by the learned counsel, Mr. Raut, for the petitioner. Learned counsel upar appearance likhchante na. The learned counsel for the petitioner that the interim order dated 7/11/2024 may be extended. Para. The interim order dated so and so, say it lekhibe. Say or 7/11/2024 shall continue till the next date of hearing.
Oblige.
Next date doesn't mean that a calendar date. Next date means a date of posting when the matter is taken up.
Well,
That's the interpretation. Long back. Yes. Agree, sir. Give a date on consent. What a date kar diyuntu. Wo hai.
after Bhagisar.
What kuhantu. June chahunchandi.
Yeah.
On consent list on
24.
24/6. Yes. That's the 5th working day or 6th working day. Yes.
Item 2.
May I please, your lords?
Mr. Priyaranjan Singh for the petitioner.
My lord. Here the petitioner is the wife of the opposite party.
Yes.
The opposite party filed a petition under section 13(1)(a), my lord, for divorce, decree of divorce before the learned judge, family court, Cuttack, my lord.
Yes.
The husband is, my lord, serving in a police department here, my lord.
Yes.
The wife is, my lord, residing with her minor child at the parents' house. My lord, due to her inconvenience, filed this petition, my lord.
Parents' house at which place, sir?
Remote village, district of Dhenkanal, my lord. And nobody except old father, nobody.
Had learned counsel for the petitioner. The petition has been filed by the wife, who is the opposite party, in CP number 184 of 2025, pending before the learned judge, family court, Cuttack, filed by the opposite party husband under section 13(1) of the Hindu Marriage Act. It is submitted by the learned counsel for the. It is submitted that due to no, as the marriage has run into rough weather, petitioner wife now stays with her parents and child at a remote village in the district of Dhenkanal. She has difficulty in attending the matter at Dhenkanal.
Cuttack.
At Cuttack. Hence the petition under section so and so 124 bodhe.
Only 24.
120 only 24. Section 24 of the Civil Procedure Code, seeking direction for transfer of the CP from Learned Judge Family Court Cuttack to Learned Judge Family Court Dhenkanal. Na kame khana kara?
Dhenkanal.
Dhenkanal gote. ଆପଣ ରହୁଛ ଢେଙ୍କାନାଳ ସଦର ବଳରାମପୁର ଆପଣ PS ଢେଙ୍କାନାଳ ସଦର ଲେଖିଛନ୍ତି ରିମୋଟ ଢେଙ୍କାନାଳ ଲେଖିଛନ୍ତି ଆପଣ ଯୋଉ ସବମିଟ କଲେ
ସଦରଟା ଆଜ୍ଞା ବହୁତ ବଡ ଏରିଆ କଭର କରୁଛି
ଆପଣ ଢେଙ୍କାନାଳ ଲୋକ କି ଆଉ କାହିଁ ସେଟା କହୁଛନ୍ତି ବି କନଫିଡେଣ୍ଟ ଜୋଗ୍ରାଫି ବିଷୟରେ କନଫିଡେଣ୍ଟ ଥିବେ ନା ଲୋକାଲ ଜଜ୍ କୁ କହିବେ ଢେଙ୍କାନାଳ ସଦର ବହୁତ ଦୂର ବାଟ because you see the order becomes somewhat contradictory. I start with the order, end up issuing stating that Dhenkanal Sadar, PS Dhenkanal Sadar, District Dhenkanal. Dhenkanal, so all places are connected. That's all. There are some distance places, but Sadar is not a remote place of Dhenkanal. Remote village in the district of Dhenkanal, that should not have been there. It is your submission, but still then it is reflected in the order. Cuttack Sadar da kon hobo? Remote na nahi. In fact, nowhere it is Sadar is a common British legacy. So it is not remote place. Issue notice along with this order, fixing early returnable date. Subpara requisites for issuance of notice by SP/registered post with 30 be filed. How much time, sir?
Within a week.
Within 7 days. 5 working days. 5
working days.
Within 5 working days. List after SR. Liberty to mention for listing before the assigned bench. Yes. IA hard learned counsel for the petitioner. Stop. He reiterates his submissions as noted above. Issue notice as above. Accept one set of fee as well as postal requisites. In the interim, it is directed that further proceeding in the CP number 184 of 2025 pending in the court of judge, learned judge, family court shall remain stayed till apna court date diyantu
24 June.
Okay, after vacation jauchunti shall remain stayed till 25/6/2024 list on 23/6/2024 2025 ସବୁଗୁଡା 25 ହବ 24 ଡାକୁଛି 25/6/25 list on 23/6/25 liberty to mention for listing before the assigned bench. ऊपर भी लिस्ट ऑन कर देबे डेट टा समान कर देबे पिटिशन रे टीआरपीसी पिटिशन रे समान डेट कर देबे यस
Item 3.
Mr. PR Chatoi for the petitioner. Yes,
Petitioner before my lord is the wife
yes.
and filed this petition on section 24 of the CPC.
Kindly speak to the microphone. ଆପଣ ଯେତେ କହିଲେ ବି adjust କରୁନାହାନ୍ତି every day I have to tell. Again today evening we will have to adjust that. ମତେ ମନେ ପକେଇ ଦେବେ. Yes.
Now petitioner is the wife, my lord.
Correct, sir.
Filed this petition for seeking transfer the CP case number 364 of 2023 from the Court of Law and Judge Family Court, and the petitioner is now staying with her father's house at village Balipatrapur, PS Tangi, near Khordha, my lord. And the present petitioner has also filed a criminal proceeding under section 144 of BNS 2023 in the court of Khordha, and wherein the present opposite party has already entered appearance. And I have already filed the copy of the orders showing his appearance on 17/2025. So, my lord, the petitioner having a small child of 1.5 years age, my lord. That is, he gave birth on a child on 23 November 2023. And he has no source of income. In fact, depending.
She stays with her parents.
My lord?
Stays with her parents.
My lord. Having a small child of 1.5 years.
Same order as 2. ଢେଙ୍କାନାଳ ସେ ବର୍ତ୍ତମାନ କୋଉଠି ରହୁଛନ୍ତି?
ବର୍ତ୍ତମାନ ଏଟା ଖୋର୍ଦ୍ଧାର ଯୋଉ ଟାଙ୍ଗିରେ ରହୁଛି ବାପା ପାଖରେ। Daughter of Kaulas Chandra, village Balipatapuru, post PS Tangi, district Khordha.
At present residing at Chandrabhaga Nolia se kain lekhile?
ସେଟା ସେ ହଜବେଣ୍ଡ ଆଡ୍ରେସ କଷ୍ଟ ଟାଇଟଲ ଅନୁସାରେ ସେଥିପାଇଁ ଦେଇ
କରିଛନ୍ତି। କରିଦେବେ stays with her parents in a village at post PS Tangi, district Khordha. Good wife. To initiate korchandi 1311 way seta one at Learned Judge Family Court Puri.
ପୁରୀ ରେ କରିଛନ୍ତି ଖୋର୍ଦ୍ଧାକୁ ଟ୍ରାନ୍ସଫର ହବ।
डाउट रहला ना कोन क्लियर त हस्बैंड कले पुरी रे केस वाइफ रहिले खुर्धा रे आसी टांगी रे रहिले once transfer from the Learned Judge Family Court Puri to Learned Judge Family Court Khordha. Same order, how much time, sir? For requisites?
Requisites within 5 working days, your lords.
Within 5 working days. IA, same order. Date केबे चाहछन?
After vacation or lords.
Date केबे कोन? List on interim order to continue till केते करथिले? 25/6 list on 23/6. Proper. Yes.
Item 4.
Please. Mr. Anjan Kumar Biswal for the petitioner. Mr. Sanjeev Swai, AGA for the state. Yes.
The petitioner is the PG go down lesser, my lord. And by annexure 1, the agreement has been to hire the go down.
This is which assignment, Mr. Biswal?
Yes, as PDS, come on.
PDS.
Yes, ma'am. Your lordship, the petitioner is said to challenge the notice issued.
Yes, please. He stood up. So
ନାଇଁ ମୁଁ ଏଠି ରଖୁନ୍ ତ ଏଟା ଅଛି ଏଥିରେ ରଖିଲେ ସେ ନଷ୍ଟ ହେଇଯିବ ସେଇଟା
no, that's fine. He stood up for some reason. So
your lordship for a moment see annexure 12 11 and 12 your lordship may see
yes, but is it the best option to challenge a notice instead of answering?
because they have directed to deposit the amount. It is an audit objection. The loss which was sustained during the
Notice to deposit the amount.
yes my lord.
Kindly show that notice.
My lord, your lordship may see annexure 13 your lordship may see page 138.
Yes.
Your lordship may deposit the cost of rice, the lesser PG Kotrapa, Salipur. Deposit of cost of rice and wheat stock damaged in PG go down Kotrapa, Salipur in cyclone storm Fani, my lord. And they have here the calculation sheet, your lordship may see.
So you entered into an agreement.
I entered into the agreement because they have hired my go down.
Correct.
Status
In that agreement or contract, any provision to this that covers this contingency?
Yes, my lord.
Kindly show that.
For the moment, kindly calculation sheet, your lordship may see what they have done.
Completed, sir. Seeing the calculation sheet has been completed by me.
Insurance coverage 78 some lakhs, my lord. Because insurance I have done on behalf of the corporation, the amount has gone to the corporation, and now they have demanded 13 lakhs, which is the
balance amount. Total loss minus insurance.
I should not.
No, you please show the clause or the paragraph in the contract.
Yes, my lord. Yes,
kindly.
Yes, my lord. Your lordship, page 44 of my brief. 43 is the 7.8 is this clause, my lord. 43.
Since it's a long annexure, please just keep some time.
I
44, yes, consequence
44
of
is
a
the
shortfall.
7.9. Consequences of a shortfall, my lord.
Yes.
If OSSC suffers shortfall, then the operator shall pay OSSC the acquisition cost. This is important, my lord. The OSSC the acquisition cost of the total quantity of shortfall within 7 days. That of I am not on that. I am on the second one. The operator shall not be liable to make good any shortfall, pay any default interest pursuant to this clause 7.9. If such shortfall is caused by
kindly show for force majeure event.
Force majeure, my lord, clause.
Any event mentioned, specified?
Yes, my lord. It is there during the cyclone Fani.
No. Fani you have showed in 138, page 138.
No, there is a inquiry report and
no, I am not there.
Force closure clause.
Force majeure clause.
Yes, my lord.
Your event.
Yes, my lord. I am going to that. Yes. My lord, here 54 page, running page 54, my lord. Good. Your lordship,
Please.
11, clause 11. Force measure. 11.1, force measure event.
Correct.
My lord, a force measure event means any act, event, or circumstances, or a combination of act, events, or circumstances, or the consequences thereof occurring after the date of the agreement, which is beyond the reasonable control or either party, the affected party, such that
straight away come to the which cover?
B. My lord.
B1 capital A.
B Roman 1 capital A.
Art Learned Counsel for the petitioner. Appearance lecture. Mr. Sanjeev Swami, AGA for the, you will appear for the corporation?
No, my lord, corporation notice is to go.
What my submission is, your lordship, kindly see page 137 and 138. That is answer 12 and 13. This is the notice, demand notice issued long back on 5/9/2024.
No, he has, I placed 37. 137, 138, I marked that.
Yes. And that in the meantime, if you want to place the interim application, then let him deposit some amount.
Why? I don't understand, my lord, why I will deposit it.
But the thing is that
with regard to merit
but the thing is that it is a classic case where after they appear, if I am the judge, I will direct them to deposit here in court, then I will decide.
Yes.
After seeing those clauses of contract, you have marked.
Actually, what happened in the meantime, we don't know.
No,
this is the
Mr. Swine, there can be a case. There can be a case.
Yes.
He doesn't insure.
Yes.
He doesn't insure. Leave it like that. That's a default on his part to insure the property and the stock.
Like that.
Because he has insured, It is not the corporation was insured. That is Mark's submission. He says,
Yes.
I insured, they have received 78 lakhs of my insurance.
No, they have ensured, but what happened in the meantime? There must have been some
Yeah,
claim and
purchased it,
settlement
paid
must have been.
145.
That
Could
part
be, could
we are not aware of that.
There could be,
That
yes,
could be.
yes.
Ah.
I mean, the time, in last, say, almost now in 6 months.
ନାଇଁ ଆଜ୍ଞା 25/3 ରେ 145 ରେ ପୁଣି ନୋଟିସ ଦେଇଛନ୍ତି ତାର ଇଣ୍ଟରନାଲ ମେମୋ ଦେଖନ୍ତୁ
25/9
145 ରେ ଦେଖନ୍ତୁ ସେଟା ବି ମୁଁ ଚ୍ୟାଲେଞ୍ଜ କରିଛି NSR
No,
ସିଷ୍ଟମ
we do not know, could be something has happened and they have, let them respond. Let them respond.
yes ma'am
Yes. Notice in both. Notice in both.
Yes. कौन लिखले? AGF और OP number नहीं appearance आगे लिखिए सब नल भूलभाल है जो परे. Vimal Kumar Biswal for the petitioner, Mr. Sanjeev Swang AGF for OP number 1. OP 2-3 अब कुछ लिखिए नहीं blank रहेगा because it's a fresh matter. The hard learned counsel for the petitioner, the learned counsel for it is submitted that the petitioner is aggrieved and challenges the notices 13-14.
my lord notices issued on under annexure 12 13 14 and 16 same notice
Annexes 12, 13, 14 and 16. देखिए लिखिए issued by so and so dated so and पर specify कर दे. Either you put it on bracket लिखिए notice issued by so and so bracket annexure 12 then 13 write correctly. It is submitted that the petitioner entered into an agreement. So what typical ना उड़े कहले तारा? What is that storage कौन?
agreement civil supply for construction and utilization of the PG go down
Yes, page 18 देखिए लिखिए for construction and utilization of
PG go down my lord 2500 MTC go down at
2500
2500 metric ton
MTC go down at Salepur.
Kotak.
Just look at page 18. Into bracket Kotak, don't make mistakes. Under Odisha
Under
EG 2013 scheme. The super cyclone Phony intervened. That was a cyclone Phony. Cyclone Phony intervened
in June
he intervened no. Hit Odisha in the year
2019 June 2019
hit Odisha in June 2019, causing damages to the godown as well as the stock. The learned counsel refers to the clause for 44 out there dekha to Mr. Biswal.
page 44 my lord 44 7.9 Roman I
Page 44 7.9
A Roman I
consequent of a shortfall.
A Roman 2
A Roman
small a Roman 2
small a Roman 2. What एमती लिखिवे small a लिखिले तापरे dot तापर लिखिवे सपरा the operator should be liable. You have to be particular when you are quoting a proposal. When something is left dot. Then 2 1 and 2.
1 and 2 nice sir.
No, it was not
khali 2 ta Roman 2 ta
not beyond 24 months.
no I'm not 24
Tell
months
2.
na
2. Sorry. ଆପଣ 7.9 जोटा पेज 44 रे अछि सेटा देखैबे मते मु कहि देबी केंति करिवे. ଆପଣ डिक्टेशन देले लिखि परिवे 7.9 consequence of a shortfall, then small a, then तीनटा छक्की मारिवे तापरे लिखिवे the operator shall not be liable to make good any shortfall or pay any default interest pursuant to this clause 7.9 if such shortfall is caused by colon then tinta cross then Roman 2 a force majeure event semicolon. So this you have to take it from page 44. You just show me how I will let you know. He further refers to the learned counsel further refers to the then page 54
11 clause
पेज गुड़ाक आपणकर जो डिक्टेशन लेफ्ट मार्जिन रे रखंतु पेज रे सो दैट यू कैन रेफर 4954 जोड़ा डाकुची जोड़ा लिखिए
11B Roman 1 Roman I
11
A.
dot force measure, then 11-1 cross
A
sorry 11-1 cross
11-1
major
A
event.
Roman I,
major event, then
A Roman I
A Roman I
and
B
B Roman I
capital B,
capital A.
sorry capital A. It is submitted that as per the terms of the contract, the petitioner is not liable to pay any amount further. So, जो calculation sheet टिके देखे हुए author
आगे।
144
आगे
no demand rate थिला page 30
insurance देला सर
as would be further it as would be evident from the letter of the corporation OP number 2 and 3
137
dated 25/11/2024
25/9 रे भी सेटा अछि ता पूर्वटा 12
and 25/9/2024 25/9 into bracket लिखियो annexure 12 25/11 into bracket annexure 13 out of the total amount of damages 95,21,811 salvage value of auction rice 3,32,53 has been deducted out of the balance. Rupees 78,77,785 has been paid by the insurer to the opposite party corporation. The insurance was the insurance was made by the petitioner
on behalf of the corporation.
on behalf of the corporation. Issue notice along with this order. The learned fixing early returnable date करते हैं. Fixing early returnable date. Learned AG upon advance copy served appeals and waives notice on behalf of the OP1 state government department. Issue notice to the opposite party numbers 2 and 3 by speed oblique restored post with AD.
In 3 working days.
Within with AD stop. Requisites for issuance of notice shall be filed within 3 days, 3 working days. Yes. List after SR. Liberty to mention for listing before the liberty granted to the parties to mention for listing before the assigned bench. Yes.
2 IS.
Why 2 IS?
Because one is for stay of this the demand notice, and another is for release of my dues, which monthly dues they are not.
That cannot be done in that is a separate cause of action.
I know for that reason.
You want to not press or
That I
why you are not filing to read more number of writ petitions? You should file more
Yes,
number
sir.
of writ petitions.
I have not.
As a lawyer, because claiming
Claiming-
challenging a notice and claiming a
It is not permissible under.
no, maybe I mean connected, but definitely completely different prayer and adjudication is different. IS 6632 of 2025. Issue notice as above. आगे लिखिए IS 6625 of 2025. The hard learned counsel for the petitioner. Stop. He reiterates his submissions as noted above. Issue notice as above. Fixing early returnable date. The learned AGA upon advance copy served, appears and waives notice on behalf of OP number 1. Issue notice to the opposite parties 2 and 3 as above. Accept one set of process fee as well as postal fees. The learned AGA opposes the prayer for interim order, stating that the notices were issued on 25/9/24, 25/11/24.
ତାପରେ ବି
The learned counsel for the petitioner in response submits that the last of the notices is dated 7/4/25.
25/3/25
25/3/25.
145 space
25 into bracket annexer 16. Para. It is submitted by the supporting the prayer for interim order. The learned counsel submits that from the materials available on record, prima facie, the opposite parties could not have made the demand as per the terms of contract. Opposite parties 2 and 3, not 1. Opposite parties 2 and 3 would not have made such a demand. Para. As an interim measure, it is directed that there shall be stay of the demands made in annexers
12, 13, 14 and 16.
12, 13, 14 and 16. The said demands being a single demand. ନା ଅଲଗା ଅଲଗା ତ ନୁହଁ
ନାଇଁ 13 ଲକ୍ଷ ପ୍ରଥମେ ଦେଇଥିଲେ ତାପରେ ଗୋଟେ 15 ଲକ୍ଷ ଦଉଛନ୍ତି
ଓହୋ ଆଚ୍ଛା
କୋଉ ହେଡ୍
ଗୋଳମାଳ ହେଇଗଲାଣି
କୋଉ ହେଡ୍
ଡିମାଣ୍ଡସ୍ କରିଦେବେ ଆଜ୍ଞା ସେ ଡିମାଣ୍ଡସ୍ ଠିକ ଅଛି ଟୋଟାଲ ଠିକ ଅଛି ତ ସେ ଡିମାଣ୍ଡଟା କଣ କହିଦେବି as an interim measure it is directed that there shall be stay of demands. The interim order to continue shall continue till the date fix karantu. Interim order shall continue till 28 list on 23 liberty to mention for listing before the assigned bench. Liberty granted to the parties for listing before the assigned bench. For mentioning, liberty granted to the parties for mentioning to list before the assigned bench. ऊपर डेट से आप सेम पकेइबे yes
item 5
why for orders Mr. Das
Lord, there is a IA pending for condonation of delay. That is IA number 431 of 24.
notices have not been issued yet.
No, my lord. On the last occasion, it was only on the for court fees. Today, it is listed for section 5 application, my lord. That is there, my lord. IA number 431.
Just a second, let me go through the earlier orders because it's an old matter also.
My lord.
It's a reference in 46. What about LA 54 of 2019?
My lord, 54 was for reference for the last order itself. My lord, LA 54 there, the court fee was exempted. So we have read on the last occasion that our court fee also be kept in abeyance. And on the last order, Honorable Court exempted the court fees by referring LA 54. That was only for reference, my lord.
How this Vijay Bharat Mahapatra, Chief Engineer Construction, East Coast Railway, they are connected with this matter or they are not
No, my
connected?
lord, they are not connected. Only for the purpose of court fee. There was a similar order, so we have.
So by last order dated 24th of March 25,
My lord.
Mr. Swai, you have copy of that order?
My lord.
Mr. Prabhu?
Yes, my lord. I can see that, my lord. So it was the
Yes, look at it has been already allowed that it shall be kept in abeyance.
my lord.
Assessment and payment of court fees.
My lord.
The IA ଲେଖନ୍ତୁ 431 of 2024 ଉପରେ cost title ହେଇଗଲା ଠିକ ଅଛି appearance ଲେଖିବେ Mr. P Das for the your P Das or PC Das
P. Das, my lord.
Mr. P Das on behalf of for the petitioner on behalf of along with Mr. Sushanta Kumar Das senior counsel Mr. Prabhu Prasanna Behera
My lord.
additional standing counsel for the opposite party କେତେ ଜଣ ଅଛନ୍ତି
My lord, only one opposite party, my lord.
So why you have not made the project proponent or the a party?
Lord, it was only for enhancement. Lord, for that purpose, my lord. There
No,
is,
I understand, but
Lord,
who is the affected party for enhancement?
Lord, that is true, my lord.
You are simply making collector or they don't pay or they are not concerned also.
Right. My lord. My lord, delay period is as shown is 70 days. My lord, total time period is 143.
My lord. My lord. No, there's an old act. My lord. Yes. Yes.
Next, please. Six, Mr. Samal. Yes, please. Mr. N.R. Samal for the petition appellant. You want time to pay the court fee, extension of time.
Extension of court fee and my lord condonation of delay also.
Ago court fee not dele apana to properly constituted habani na. Unless you pay the court fee, it is with defect, it is defective LA now, 51260. That's the difficulty. IA 78 of 2025. (78) of 2025. Mr. N.R. Samal for the petitioner. Upare LA rahila, order sheet IA rahila. The IA has been filed under section 149 of the CPC for a allowed with so and so of the High Court rules. for extension of time to file, to extension of time to deposit the deficient court fees. How much time? You are praying?
My lord,
One more time.
1 month.
As paid for 4 weeks further time is allowed. 6 weeks kar diyo. 6 weeks further time, 4 weeks, 1 month further time is allowed. The IA stands disposed of. SRB made upon deposit of the deficit court fees as undertaken within a period of 1 month. Certified copy
I have already annexed, my lord. Sir.
IA 80 of 2025. It is submitted by the learned counsel for the certified copy. तो नहीं है दे रहे हैं. Scan the scan ही नहीं देखो तो काढ़न तो फाइल काढ़न. कौन लिख ले? The IA has been filed for extension of time to file certified copy of the order. Imbue. It is submitted by the learned counsel for the appellant petitioner that the certified copy has already been filed, which forms part of the record. पाउचुन ना पाउना देगा, मते दे दियों.
My lord, my lord, exemption ପାଇଁ ଗୋଟେ IAB file ହେଇଥିଲା for filing of
ସେଇଟା ତ order ମୁଁ dictate କରୁଛି sir. That order I am dictating. I am dictating order in the IE you have
Fine.
filed for exemption. In response, you said that already filed. I am now started searching for that. ଆପଣ ଯାହା କହିବେ ସେଟା କରାଯିବ. ଫାଇଲ କହିଛି ନା ହେଇନି sir?
I will take instruction from my clerk, my lord.
ଆରେ ନାଇଁ ଆଜ୍ଞା ଏଟା କଣ?
File ତ
Since the deficit court fees, the period for filing of the deficit court fees has been extended further by 1 month. To further 3 weeks time granted for filing of the certified copy. The IA stands disposed of. Because in scanned copy, if it is not colored copy, so then one cannot know whether this is the certified copy. Everything looks black and white.
my lord.
I checked your brief. In your brief also, everything is black and white.
Black.
The third aspect that could have been downloaded from this scanned copy.
My lord.
So these are the added issues. Angularity you have to dimensions in paperless. So that I was trying to understand. But you are not sure, and the office note doesn't say that you have filed the certified copy.
I will take care of it.
So for certified copy, 3 weeks, 4 weeks kar diyo. Should have 1 month, and 4 weeks kar diyo. You obtain and file it. Disposed of. SRB made after filing of the certified copy as undertaken. Yes. Next, please.
7. Obligement.
Mr. Your name is sir, Mr. A.K. C. Behra.
Abhijit Mohanty.
Mr. A. Mohanty for the appellant, for the petitioner. Learned counsel for the petitioner submits that notices were issued by order dated 7/3/2025.
My lord, I have already.
Mr. Ramachandra Jena submits that he has instructions to appear on behalf of the opposite party. Wakalatnama sir file kale?
I have already filed in the registry.
He has filed the Wakalatnama in the registry on
Yesterday.
On 23/4/25. Thus Wakalatnama shall be taken on record. Scanned copy be updated. The office note regarding non-appearance of the opposite party stands complied, shall be ignored. When do you want, sir? Kibe chahunchuni, sir?
No, 8th, sir. 8th May. 8th May.
Mr. Mohanty, 8th May.
My lord.
On consent list on 8th May 2025.
Till then, my lord, interim order to be continued.
Interim order is there, sir?
My lord.
The interim order dated 7/3/2025. shall continue till 12th May 2025.
Obligation.
Yes, please.
Item 8.
My lord. Item 80.
Mr. Das,
Lolatendu Rai.
Mr. Lolatendu Rai, for the petitioner. The learned counsel for the petitioner submits that notices were issued by earlier by order dated 7/3/2025. The office note dated 23/4/25 indicates the following. Serial number 2 रे আছে देखिए लिखते हुए neither ready up to kindly be seen. The track consignment shows the track complaint doesn't show the up-to-date status regarding service. Registry shall obtain the track consignment and put up note accordingly. When do you want, sir?
My lord, page 5, paragraph 6, kindly is seen, my lord.
No. When do you want, sir?
Bhubaneswar, family code Bhubaneswar to Jagatsinghpur family code.
Sir, the date, the next date, and because the notice is yet to be sufficient. Suggested date.
Next week, my lord.
कर दियो डेट करंतु
9/5.
लिस्ट ऑन 9/5/2025 register to do the needful.
Yes, ma'am.
Item 9.
Lordship, late
Yes.
late son होगा late husband ही जैसे late son हो रहा है.
Sir, which order, sir?
Order dated 10/4/2025. ଆମେ ସାବିତ୍ରୀ ଜେନା ତା ପୁଅର ଇନ୍ସୁରାନ୍ସ ବେନିଫିଟ ପାଇଁ କରିଥିଲେ କ୍ଲେମ କରିଥିଲେ ତେଣୁକରି ତାଙ୍କ ଲେଟ୍ ହର ସନ୍ ଲେଖା ହେବା କଥା ଲେଟ୍ ହର ହଜବେଣ୍ଡ ହେଇଯାଇଛି.
Late her, no, her late son.
ହର ଲେଟ୍
Made by
ସାବିତ୍ରୀ ଜେନା
insurance କିଏ କଲେ?
ତାଙ୍କ ପୁଅ କରିଥିଲେ.
ପୁଅ କରିଥିଲେ insurance?
ନାଇଁ ପୁଅ LIC କରିଥିଲେ ତାଙ୍କ ୱାଇଫ କି ନୋମିନି ପକେଇଥିଲେ. ୱାଇଫ ମିନ୍ ଟାଇମ୍ ବାହା ହେଇଗଲା 85 years old. ତେଣୁକରି ତାଙ୍କ ମା ଯେହେତୁ ପ୍ରେୟାର କରିଥିଲେ ଆମକୁ ଦିଆଯାଉ LIC ବେନିଫିଟ ଟା ତେଣୁକରି ଲେଟ୍ ହର ସନ୍ ହବ.
That was your submission that she is the beneficiary, but she is not the beneficiary.
Yes.
My question is that who was the proposer in the insurance? किए करथिले?
Savitri Jena. That's it. I don't mention Savitri Jena, the petitioner.
से करथिले?
He said the son.
ये काई कले से काई कले माप पाबे मागुथिले काई पैसा?
Sorry.
अत्तेरी जणे इंश्योरेंस करे जणे बेनिफिशियरी.
लर्डशिप इंश्योरेंस करथिले तांको पुओ साबित्री जेनाଙ୍କ पुओ करथिले इंश्योरेंस जेहेतु तांको स्त्री मिन टाइम
सेटा फिर जेहेतु आप करन. That is how you are confusing the issue. The question is very simple. Who was the proposer in the insurance? किए करथिले?
प्रपोजर इज द साबित्री जेना सन
तांको पुओ. तापरे से करिथिले मेड बाय हर सन लेखा हबो हर लेट सन हबो. Head learned counsel for your name, sir?
सत्यपूर्ण पंडा.
Satyapurna Panda.
Vibhudatta Vishwar.
This submits that there has been a inadvertent typographical error in the order number 1 dated 10/4/2025. In the subpara paragraph 1, in place of beneficiary her late son being the insured, her son being the insured, for the policies made by her.
Let's
पूरा sentence replace करते हैं तो in place of the sentence, in place of the part of the sentence, she being the beneficiary, her late optuneki, late dash husband, quote, the following shall be replaced. She being the beneficiary, her late son being the insured for the policies made by her late son. Clear? Quote ends. The corrections be carried out, the order shall be replaced. The type about nature certificate copy.
नहीं
The corrections be carried out as per rules in the order dated 10/4/2025. Yes, next.
Item 10.
When they appear, you bring to their notice. Because if the notice is issued already with the order, so they will be appearing with the impression of this order. That's obviously it is pending. I understand, but still then you also mention when they appear. They will object to this. Because the insurance companies tend to repudiate claims. Even they will, on the basis of High Court order, they will repudiate. That is submitted before the High Court that the insurance was made by the husband. It is actually made by so and so. All these things they will say. So please take care of that. Yes.
I am for the opposite party.
Okay. IA stands disposed of. IA is disposed of. Item Dakonto.
Item 10.
Mr. Sakti Sekhar for the petition on behalf of SK Samal for the petitioner. Mr. PK Patnaik. So for the opposite party, corporation, कितने number opposite party?
10.
I am opposite party 4. Actually opposite party 4. But
Mr. Sanjeev Swahi, AGA for opposite parties 1, 2, 2, 3. Mr. Patnaik, opposite party 4 and 5. Learned counsel for the petitioner seeks accommodation to seek response and instruction of the petitioner with regard to the counter filed by the opposite party. आपण फाइल करछंती
4टा फाइल है किंतु सेटा 2 बोली रही जे भूल है जे हम पिटिशन 2 ही जे
ताको कर दियंतु ताको गोटे अमेंडमेंट फाइल करिया पड़ियो
अमेंडमेंट फाइल करिया पड़ियो
ओराली कोर्ट रे आज गोटे चिठा काली गोटे चिठा सब दिन कटा है कि सेटु तो हबनी सो फाइल अमेंडमेंट
तारा से करेक्शन
जदी माने जोटा को हमर एठी लोक कोहाउची हमर प्रैक्टिस रे चलची ओडिसा हाई कोर्ट रे मिसफाइलिंग होची ऊपरटा भूल हे गला सेटा मिले नि आ कान से जो नंबर रे पड़िबो सेटा मिलिबोनी आपनकर सब नंबर फंबर ठीक अछि अपोजिट पार्टी भूल हे जाय So you correct it by filing a affidavit by the said same person who has filed the affidavit. ଯଦି ସେ incumbent ନଥିବେ the next incumbent will file.
ସିଏ ଅଛନ୍ତି ନା ଆରି ରେ ଅଛନ୍ତି ରିଟାୟାର୍ଡ ପରେ ରିଏମ୍ପ୍ଲୟମେଣ୍ଟ ରେ ଅଛନ୍ତି.
Retired employee should not file affidavit.
ସେ पर ଅଛନ୍ତି ଆରି ରେ
ସେ जो ଆପଣ ସେ କାଉଣ୍ଟର ରେ ଦେଖନ୍ତୁ ଗୋଟେ ଆପଣ ଆଭରमेଣ୍ଟ ନେଇଛନ୍ତି look at that averment.
ସେ ସେତେବେଳେ ଥିଲେ ଲ ଅଫିସର ଥିଲେ.
ନାଇଁ ସେତେବେଳେ ଚାକିରି ଥିଲେ ନା ରିଟାୟାର୍ଡ
ଚାକିରି ଥିଲେ.
ଆଉ ତାହେଲେ କଣ ଅସୁବିଧା ଅଛି
ଏବେ ରିଟାୟାର୍ଡ କରିଛି.
So anyone can file for that.
ନା he is now in Ari also re-employment.
Whatever. ଆପଣ ଯୋଉଟା କାଉଣ୍ଟର ରେ ଫାର୍ଷ୍ଟ ପାରାଗ୍ରାଫ ଲେଖୁନାହାନ୍ତି ଦେଖନ୍ତୁ I am acquainted with facts of the case, relevant official records and competent to swear this affidavit. See, competent word is very important, and that competent, a person retired who is, whether he is competent, that's a issue.
Now also he is also filing the affidavit.
आपण टिके आरी रो देखिबे टर्म्स एंड कंडीशंस एंगेजमेंट सेतिरे ऑफिशियल कैपेसिटी ताकर सेटा नाही ताकर acquainted अछन ठीक अछि बट एनीवे सेटा त आपण जे फाइल करछन ही वाज इन सर्विस दैट्स नॉट एन इशू हियर कोन लिखले counter affidavit filed on behalf of the opposite parties 4 and 5 आपण चारि ना का पे फाइल करछन
चारि मैनेजिंग डायरेक्टर
चारि
हां चारि पांच कॉर्पोरेशन पे तो
both 4 and 5 the learned counsel Mr Patnaik appearing for the OP number 4 and 5 submits that inadvertently the counter affidavit on behalf of 4 and 5 has been captioned as counter affidavit. Captioned as quote कर दियो quotation लिखी देवे page 61 रे अछि देखि counter of behalf of एटा आपनकर इंग्लिश रे भी बडला लेक्चर counter of behalf of opposite party number 2 माने it has माने I mean it has gone really off track. OFF off, which needs correction. Para. He submits that he will do the needful for filing a petition for correction of the affidavit. केबे फाइल करिवे?
Within 1 week.
Second off is that
not 2 weeks, my lord. After 2 weeks, my lord.
you stop this filing of retired. Actually, you have stated that he was appealing or he was working as RE. RE ro full form kono?
Re-employment.
Re-employment. This stop this filing of affidavit by RE.
law officer ke nahanti fail kare.
Then you are not getting it, sir. Company रे के नाहंती कहले हबो तांकर आउ के कंपनी रे के नाहंती see the sole surviving omnipotent officer.
No.
See, that plea you can take, but you have to state that since I'm the only person working in this company employed on rehabilitation re-employment, and look at the company's rules and regulations also. Nowhere it authorizes that persons on re-engagement, contractual engagement shall file affidavit. The problem is that this issue, if it hits you at any stage, maybe in Supreme Court and High Court, you are nowhere. Because if consciously you have filed. Strict rules of pleadings follow only. The pleadings are not being struck off like the lower court. But it's a CPC provision. And carefully you have not said that I'm competent to swear this affidavit. You have mentioned aged about 61 years. So it's beyond age of superannuation. And so, if he has been authorized by any board resolution or any official process, if he is authorized, so please mention that also. That would help you. Even some of the learned judges are so strict. I have seen senior judges earlier also, that they don't even put a pencil mark in an affidavit. That they say because it's a kind of party's brief, a party's affidavit. So why the judge will put any pencil mark? That is, and it's correct also. But at times we need to put pencil mark only because so many pages reference is there. So either highlighter or pencil mark, they don't do that. Yes. कौन लिख ले केबे चाहुछन्ती केबे करि परिबे
2 weeks
date sir give a date sir I'm sorry he has taken adjournment 24/6 list on 24/6 कौन लिख ले do the needful for filing petition for correction of the affidavit and 6 accommodation for 2 weeks. As prayed for by the Learned Counsel for the petitioner, list on 24/6. On consent कर दो जी you agree for 24/6 ना आपण 24/6 रे agree राजी अछंती तो ना आउरी आगुआ दरकार आपनकर
एटा already this matter already covered by judgment of coordinate bench, my lord.
Cover because once you tell that it is covered, they will run for cover. So you provide them cover, you agree for the cover also, so that I can cover it.
Last
on consent distance 24/6.
11. Item 11, your lordship. I've served the copy of the rejoinder and the consolidated cost title to the opposite party petitioner.
Mr.
Lakshmikant Tripathi, lordship.
No, your state So Lakshmikant Tripathi, and I remember your name, but I was thinking Mr. Das is appearing on behalf of corporation.
But now,
So Lakshmikant Tripathi for the petitioner, Mr. Debaras Mohanty.
Number 1.
You are there, Mr. Mohanty?
OP number 1.
Mr.
Opposite petitioner.
D. Mohanty AGA for OP number 1. Mr. Das for OP number 2. So you have not substituted Sahoo.
absolutely, Your Lordship. I filed the consolidated cost act.
When did you file, sir?
Your Lordship.
It is submitted by the Learned Counsel for the petitioner, Mr. Tripathi, that consolidated cost title has been filed
18-3, Your Lordship.
on 18/3/25.
Your Lordship.
On 18/3/25, substituting the present entity in place of the OP number earlier, in place of the OP number 2, say Central Electricity Supply Utility of Odisha, to bracket Sahoo. Substituted by Tata Power.
Central Odisha Distribution Limited.
Tata Power Central Odisha Distribution, TPCODL. DL. Since Mr. Das submits that he has already filed Wakalatnama,
No, madam, I have filed Wakalatnama for Sahoo, madam.
so kindly file again. There may be issue regarding authorization. So Das, Learned Counsel appearing on earlier, who has already appeared on behalf of the erstwhile Sahoo, shall file his Wakalatnama on behalf of the newly added opposite parties 3 and 4 as undertaken within
Lordship may call it after vacation because he has filed a rejoinder.
within Wakalatnama file kar diyo tu. How much time for filing Wakalatnama?
Wakalatnama,
Within 1 week. Within 10 days, within 10 days. The Learned Counsel for the petitioner submits that he has filed a rejoinder
copy
on
of today. Copy of the same
18-3, Your Lordship.
Eh?
18-3/2025.
18/3.
Your Lordship.
This filed rejoinder to the counter filed on behalf of the opposite party. Erstwhile opposite party number 2. So the opposite party number 2. Copy of the rejoinder has been served on the Learned Counsel appearing on behalf
in course of
for the OP number 2
in today, madam.
today in court. The registry shall locate the rejoinder and update the scanned copy. Registry shall locate the rejoinder, bring it on record. Bring it on record. Now update the scanned copy. On consent list on after vacation no date karantu 36.
So I will also file a reply to that rejoinder.
The Learned Counsel for Mr. Das submits that he may be granted. He seeks for leave. The Learned Counsel for the opposite parties 2, 3, and 4 seeks leave to file response to the rejoinder, if so advised.
Fixing any day, madam.
36.
Item 12.
Mr. Banshidhar Bagh, Senior Counsel, instructed by Mr. G.R. Sahoo. Mr. G.R. Sahoo for the petitioner. You are there for
I am for the opposite party number 2.
Mr. T.R. Meher.
Yeah.
For OP3?
OP3 not yet appeared.
Mr. M.R. Mohanty, A.K. L.K. Behra.
Rejoinder, if any, my lord.
I will not file a rejoinder. My case is admitted. Can you compel me?
No, I instruction. I need an instruction, my lord, from collector.
Mr. AGA, Debaras Mohanty AGA for OP number 2.
Matter is simple, very simple.
Mr. T.R. Meher for OP1.
Opposite party not 2, man. Opposite party number 2.
Who is collector?
Who is the collector?
Are you sure he has authorized you? OP2.
To simply file the Bhinama, my lord.
As a capacity of chairman.
No, you check with Mr. Mohanty, the Lord AG. Usually the collector, he can because he's chairman regularly. RMC is a different capacity, could be, but let there not be confusion. Because definitely they will seek instruction. They can't afford also not to seek instruction.
Collector in fact is opposite part number 2 has the file counter affidavit.
Through you. कौन लिख ले? No, dear Mr. Meher for OP number 1 and 2, OP3 none. Yes, this is for admission.
No, notice has been issued. The lordship by order.
This is item, Mr. Bag, this is item 12. Also for admission.
Lord, here matter is very simple, my lord. By the annexed lordship mechanism is annexed 1.
The office note put up by the registry that AD not back from OP number 1 shall be ignored. You are for OP 1, na, Mr. Meher?
Miller.
So you have already appeared?
Miller.
Yes, shall be ignored. In view of the appearance of the Lorded Counsel for the OP number 1. Yes, Mr. Bag.
Initially, the petitioner, who is now during pendency of the petition, is retired on 31st January 2024, was appointed as on daily wage basis.
Yes.
Then by the annexed 1 page 10, he was appointed on his appointment was regularized.
Yes.
With effect from 1794.
Yes.
Serial number 2 is his name. You also got it, my lord?
Yes.
Then while he was working as yardman, there he was charged with some charges, and without following the procedure, he was dismissed from service with effect from 1/7/1997, 1/4/97. That was challenged before this Hon'Ble Court that without giving any opportunity, he has been dismissed. Then this Hon'Ble Court in OJC number 9627, paragraph 5 of my petition, I have stated.
So that records.
My lord.
Those OJC order or records is there.
My lord, I have stated a copy.
No.
But I have stated, there is no dispute on that, my lord.
No, I can't. It's not a question of me or you disputing.
My lord.
Referring to a court proceeding.
That should be produced, my lord.
And more so when it is available.
My lord.
How can you say that LCR is not there?
My lord. But
anyway, you have not annexed. Let us carry on hearing. Yes.
Then in OJC number 9627 of 1997, by order dated 1/5/2006, the order of dismissal was quashed with the direction.
So there are two connected writ petitions.
My lord.
Yes.
Then the order of dismissal was quashed, directing the authority to initiate fresh proceeding if necessary with further charges.
Yes.
Accordingly, they framed charges. And paragraph 6 I have stated on framing of charge, due inquiry was conducted. Then it was stated he will not be entrusted with duties relating to financial matter. Page 4 of my petition I have quoted. He is imposed penalty of 5,000, which to be realized in 5 installments. Then the period of removal is treated as suspension as such.
The punishment order.
Punishment order. So I am in service. My service is not taken away. Thereafter, what they did, though regulatory market committee take a decision to reinstate me, that was not communicated to me, nor was given effect to. Then by the annexure 2, you also may kindly see, annexure 2, page 11. By order dated.
What is their stand? What is the response to this according to you? I mean, what is their stand? I am just asking you.
And the counter affidavit.
Yes, counter or.
Nothing has been met out. Why I have not been paid my salary?
No, regarding reinstatement.
They have admitted.
Yes, Mr. Meher.
They have admitted. Now I have been retired.
Acha, Mr. Bag, you are only saying that you will be reinstated from that date. That's the only prayer.
Reinstated.
No, from the date to 25/6.
No, on this order, I joined on 1/9/2024. 2010.
Exactly. So
And
that so I have so I have got you. I have got you. That's the question to you.
Madam.
That's the question to him. That is how I'm asking this question. So I mean, yes, Mr. Meher, don't go to the facts. Please confine to the be sharp on that. I mean, point. 2586, you pass a order, reinstate. Then you reinstate him on 27810. What is the reason?
Reason will clear. I am not in the clear in the points unless I get instruction what has happened.
No. You very well obtained instruction on his. You have filed. He has filed counter.
Yes.
But not dealt. You are saying that you have not dealt with that aspect.
Not.
Agreements, I have been reinstated. Disputing that I may be entitled from 2006, but once they pass the order and I joined person to that on 1/9.
Mr. Meher, then you must realize that he's also he's ready. Though strictly speaking, it has to be from 2586. You obtain instruction. Then what happened after 2010?
Then they did not pay me the salary which I was getting from 94. They made me a new appointee and they paid the salary. The person who were appointed with me, regularly with me by the next one, they are paying higher salary. Whereas though I have been reinstated, I am paying lesser.
On the date of suspension,
my lord,
you were regularized or not regularized?
Annexed 1, my lord, page 10. I was regularized.
Yes, what is your answer, Mr.
Allegation of the petitioner is
No.
Only is that
Mr. Meher, this is a courtroom interaction of serious nature.
Miller.
Let us not make it a drawing room discussion.
Miller.
So please be specific in your reply to the this discussion or deliberation.
After getting my,
I am not disposing of, but you have to answer these queries. Legal issues.
Well, only their allegation is
no, not their allegation, sir.
But salary.
I am not asking what is their allegation, sir.
Well,
when you suspended him using your power to deal with a permanent employee when he was employed permanently. You pass a order reinstating him in 2006. Then you reinstate him in 2010 as a fresh employee. Are the facts he is stated on behalf of the petitioner by the learned senior are correct or incorrect facts?
My submission is my lord. My require instruction, my lord. Is my instruction from the authority. So that my lord, I pray for only adjournment.
No. You have said once. I to tell you that I will grant it. So please don't be regarding that. I am not saying. But unless you answer these things, there is no point in taking instruction also. Suppose you take instruction regarding his whereabouts, how he worked, what is his nature, what is his character, whether he is bad or good. Those will not help in adjudicating the matter, deciding the matter. Shall be ignored. Sita appear court. Had the learned senior counsel for on behalf of the petitioner. It is submitted that the present writ petition follows the earlier writ petitions WPC. I'm sorry, OJC number 9. I'm sorry, Lekiveni. Kati debe. In OJC number 9627 of 1997, disposed of on 1/5/2006. WPC number 9531 of 2012, disposed of on 12.09.2013.
That is for non-payment of subsistence allowance. Second one is. And it was direct.
Auri gote third achi na nahi eta third. Para. It is submitted that after the orders passed earlier by this court, the disciplinary proceeding has been completed. The petitioner was reinstated with effect from 25/8/2006. The order of reinstatement was not communicated to him. Mr. Meher, kindly also hear. Any facts as placed by the learned senior you don't agree, you can say. given effect to, was not given effect to, oblique communicated to the petitioner. It was only communicated on 27/8/2010 and given effect to. It is further submitted. The reinstatement of the petitioner is somewhat peculiar, inasmuch as he was reinstated, he was given engagement as a fresh employee. Second, fresh kauchu lecture pura, fresh. Fresh employee, which is contrary to the order passed by the authority of the RMC. In the upper annexer kichi karna hai. Employee which have with the orders which have, though the orders have not been annexed, but not also disputed by the opposite parties. The learned counsel for the opposite parties has adjournment to obtain instruction and address on the said issues. 21, sir. So, Mayor.
30th of June.
30 June.
I don't know, so 26th.
List on.
My lord, counter is filed admitting everything.
Will it be possible? Vacation asiyola. List on 25. List on consent. List on 25/6/20. 25. Liberty to mention for listing before the assigned bench.
And my only prayer is when he is taking adjournment, your lordship direct to produce the record of disciplinary proceeding wherein penalty was imposed on me and order of reinstatement was issued. They are not giving.
No, they are not disputing. I have said that not disputing.
No, my lord, not on.
It is for them. It is for them to whatever.
I am not disputing.
I have already observed so. I will not again reopen that. Why should I? I mean, why should you also, as a counsel, why should you reopen that issue? कौन लिख लेता पर? हाँ. The registry shall place on record the earlier disposed of OJC एत्ते लिखी देवे for reference. Well. Yes.
13.
Mr. Jaswanta Das for the petitioner. Mr. Devaraj Mahanti, AGA for the state. Mr. PC Mahapatra. Mr. Prabhas Chandra Mahapatra. Along with Jaswanta Das.
Yes, he was previously has given consent to me and I am.
Then it cannot be. So Prabhas Chandra Mahapatra for the petitioner. The name of the learned counsel appearing for the petitioner shall be indicated as Mr. Mahapatra. Name of the earlier learned counsel who has given consent and retired from the brief, Mr. Jaswanta Das and associates, shall be deleted from the cause list as well as the case brief from the next date. Yes, Mr. Mahapatra.
May I please, Lordship? I was appointed as a computer programmer on 15/11/2012.
Kindly look at, give an impression of your prayer, what you are praying. Re-engage.
My lord, the prayer was?
Re-engagement mandamus.
I have prayed to...
Grounds, sir, grounds kona. Re-engagement kahin chaunchanti. How do you say, justify your... Because you see, employer-employee relationship is guided by rules and... So you are not relying on service code?
Yes.
CCA rules, anything?
Yes, I'm relying.
How can is it applicable?
Yes.
First to show that is applicable.
Yes. My lord, I have been disengaged without following the principle of natural justice. So also the rule prescribed for us. Our rule.
Punitive, sir. Punitive. Disengagement which is punitive. That will be for principle of natural justice. Have you ever not disengaged your domestic help?
Yes.
But what about principle of natural justice? Why it is that day in, day out, domestic helps, assistants, drivers, peons, and other, they have been disengaged, engaged, no principle of natural justice.
With all due respect-
You say, upon Kalto Asiveni?
No, sir, with
So
all
they
due
are,
respect,
they are not going to the labor court. They can go to labor court.
my lord, this case has been already decided by this Hon'Ble court in a different writ petition. I am
So then withdraw this. Why you are further litigating? Whenever you are having benefit of a writ petition,
in a similar case, this issue has been decided.
Similar, how can it?
Let me say the factual position of the
No, sir, you will definitely say the factual position. But unless you are clear what you are pleading before the court, seeking before the court yourself, enormous quantity of fact will not help you. Minimal quantity of fact will not also help you. You must know your goal. Why? But then why the prayer is the mirror of the whole thing? Because that is what you want to achieve.
Yes.
You are on a path.
Yes.
You tell details of the path, but you do not know the goal.
Yes.
So you will be on a road to nowhere. If you know the destination, so that is how the endeavor of adjudication.
Yes.
You are officer of the court. You have to assist the court.
Yes.
Yes. You look at your prayer. The prayer is very clear.
The prayer is to quash the informed orders at Annex 4 and 6.
Yes.
And today I want to file a dead chart with a written note of submission.
Dead chart written note of submission. You rely on to submit on the this because already pleadings are there.
Yes.
It may help the court or may not, but you have to be structured in your presentation that you entered into a contract of engagement.
Yes.
The contract period is for how much time?
Yes.
Kete dina pe contract thila?
Sir, the contract, I am continuing on a contract basis.
Correct, sir.
With renewal of 1 year.
That contract was for which period?
For 1 year.
For 1 year.
1 day break. And in that process, I was continuing.
Correct, sir. What was the last contract you entered?
Yes, last contract.
You see, after preparing the date chart, you should not be, struggling on the dates.
Yes, sir. I was appointed on 15th.
What was the last date of renewal of contract?
Contract was continuing when I was disengaged. My contract was continuing by that time.
Then so it was continuing from which document, which annex?
Yes, sir. Even it on counter.
Sir, how can you discover that in your counter? You do not know how you continued.
Yes, I am continuing.
So you show from your petition the averment.
Yes.
And the annexure where you are relying on that showing your contract of engagement. Continuance.
The paragraph 2 of my
annexure?
No. The paragraph 2 of my submission.
You have not annexed.
Writ petition. No, I have not annexed. I have not annexed that part.
The Learned Counsel for the petitioner submits that. Though the matter is listed for admission after notice admission. For admission after notice.
Milord,
Let us not spend time when the document is not there.
No. Annexure 1 includes.
After notice. Counter has been filed. On being asked on which document the petitioner relies regarding his engagement and continuance as a contractual
computer programmer.
Contractual computer programmer. He fairly submits that the said document has not been annexed to the writ petition.
It is annexure 1. Annexure 1.
Then he corrects himself.
Agreement.
He fairly submits that the said document has not been annexed to the writ petition. Stuff. Thereafter, he corrects himself to say that
in annexure 1.
The annexure 1 is the document showing his contractual engagement with the opposite party? You are appearing for all.
Yes.
But that I did not ask you. Yes. So that is one is the document.
Appointment order and next with the agreement of contract.
Yes. Yes. Then what about? Then what happened? Which part of the agreement you rely on?
I was continuing with a consolidated amount of.
Which part of the agreement you rely on regarding your continuance? Because your engagement is very clear, as you have said also, that you will terminate it every year on 28th February.
With 1 day break.
So either you challenge that or you rely on that.
No, I was continuing on that condition.
That's the problem, sir. That's the problem.
But on that ground, I have not been terminated. My services are not.
It's not a ground. You enter into an agreement to be terminated on 28th February.
And then immediately thereafter, re-engagement.
Sir, I'm not asking you that whether you are re-engaged or not. But if you have agreed to be terminated on 20th February afternoon every year.
Yes.
So from 2012, 13 February 28th, you were terminated how many times?
With one day.
Sir, if you are stuck at one point, you cannot answer.
Up to 16th, up to the year.
13, 14, 15, 16. So you have been terminated 4 times, yes. Re-engaged 4 times.
Yes.
5th time you have been terminated and not re-engaged.
I was terminated on 13/1/2017. Till that day, I was continuing with 1 day break in a year.
You have been, again I'll repeat what I have said. You have been terminated 4 times and re-engaged 4 times, you admit.
Yeah.
5th time after termination, you have not been re-engaged.
Not that. That is not the case.
The agreement says that the petitioner entered into an agreement with the following clause. Page 13 the post of computer programmer may be terminated every year on 28th February afternoon and renewed from 2nd March in such a manner that there is 1 day break on March every year, subject to their satisfactory performance. The learned counsel for the petitioner concedes that he was terminated every year on 28th March on 2013. The petitioner was, not he was, the petitioner was terminated every year on 28th February 2012, 2013, 14, 15, 16. ଆପଣ 17 ରେ କୋଉ ଯାଏ କାମ କରୁଛନ୍ତି?
My termination date 3/12/16. I was terminated from service on 13/1/2017.
13/1/17 sure ତ ଦିଟା ଡେଟ୍ କହୁଛନ୍ତି ଆପଣ? ପ୍ରଥମେ 12 କହିଲେ 16 କହିଲେ?
No.
13/1/17.
13th January 2017.
16. Re-engaged on कैसे देखा जाउनी आपनकर ब्रीफ रे देखा जाउची कि से जो पेज 13 टा मिस्टर दास से डेट गुड़ा जो राइट हैंड मार्जिन टा कटि जाइछि मोर स्कैन कॉपी रे पेज 13 पाइले
13
ଏଇଟା ବି କଟି ଯାଇଛି ଟିକେ ଆପଣ ବ୍ରିଫ ଟା ଦିଅନ୍ତୁ କଣ ଲେଖିଲେ on 1st March same years केते 13, 14, 15, 16. He was disengaged on 17 January ना 31 January 17/1/2017 कोन स्कैन कला बेले से मार्जिन कटि जाउची एमपी कोन करछ yes
Milan,
how do you challenge that disengagement upon ground कोन challenge करिवार
sir, there is a letter at Annexure 2. Annexure 2, there is a letter from government that, let me read that letter.
Please.
Annexure 2. Inviting reference to the subject cited above, I am to say that the strike of computer programmers is hampering the day-to-day work of blocks as well as DRDA during the peak work season. In the meantime, an interministerial committee under the chairmanship of the Honorable Minister Finance has been constituted to address the grievances of the computer programmers, additional computer programmers, and Gram Rozgar Sevak. In view of the above, if the computer programmers do not report to their duty on or before 5th December 2016, you are hereby directed to terminate their services with immediate effect. This was the letter from the government. And I was coming to join on 5th December 2016. On the way, I met an accident for which I could not join on that particular.
So that from the annexure. Can you show that you are coming to join, met with an accident?
Yes.
And could not join.
Could not join.
So please show that from the your writ petition, averment, and annexure.
Yes. Annexure 3.
Yes.
Annexure 3 to the block development officer, Tumudi Bandha.
देखा जाउनी जमा.
I am reading that part.
ना ना ओडे नीट टाइप कॉपी दियंतु.
Yes sir.
कला आपनकर कला ना गोरा
कला
आपण पढि पडछंती
हेजी अछि
नहीं स्कैन हेगला पर तो से गला स्कैन हेला पर वेरी डिफिकल्ट आपण कॉपीटा देले आपण कॉपी
स्कैन कॉपी
नो सॉरी आई मीन मिस्टर बारिक आपण कॉपी रखंतु सर हार्ड कॉपी आछी एथि पई ए जो डिफिकल्टी होची बेले बेले just give me a moment. अरे इथरे गोटे कोन अन्य उठी जाई छी कोन एटा कोन मोबाइल फोन आनथिले ना
गोटे कोन उठी
से जो आपण जोटा पेज रे जेरॉक्स करचंती ना कोन सेटा गोटे ता देरे आ गोटे कोन उठी जाई छी अच्छा पढंतु विथ ड्यू रेस्पेक्ट आई बेग टू स्टेट दैट
टू द ब्लॉक development officer Tumibandha, unable to resume my duty, sir. With due respect, I beg to state that I am Alok Kumar Naik, working as computer programmer in your Panchayat Samiti.
से जो accident टा आपण
sir, that is followed by another government hospital document, MKCG Medical College. The next page, page number 18.
precision letter.
Dated
5/12/2016, and that was the date of medical report.
Yes. Page 18, Mr. Yes.
So on the way to join
what you can do, आपण जोटा page 17 रे टाइप कर दियंतु. Because it is otherwise readable. आपण गोटे कोन जेरॉक्स करछन सेटा पूरा आ गोटे कोन उठी जाई छी. Thereafter what happened?
Then after I was admitted in MKCG Medical College Hospital, and I got a medical report to that effect. And later on, I reported that due to such difficulties, I could not join on that date. And
anyway, you have said email on 5/5/12.
Yes. Then on Annexure 4, then Annexure 4, the order dated 13/1/2017, the order of
Yes, Mr.
termination.
Mahanti.
My lord.
How do you justify the Annexure 4, page 20, in view of the earlier order of your order dated 3/12/16?
I have disputed that document has not received in my counter also I have stated that your lordship see that appointing authority is the collector. He has mailed to the BDO Tumalikonda.
That is against you. That point is the last point.
But
That is the last, not even the last straw on the camel's back.
But I have
He
disputed that.
can give it to the peon also. Unless you dispute the
I have
BDO,
disputed. I have disputed.
unless you dispute the email that BDO or the BDO's office, he works on BDO actually, because BDO is the OP5 and it is at Panchayat level, he is an officer also.
I have disputed that document.
You have disputed that document, that medical record where? You sit down, take some time.
Yes, sir. Then
I'm not interrupting or stopping you, but he has to respond at certain level also.
Sir,
At least you have argued to certain level where he has to respond.
Yes.
Now please sit down.
Yes, I have got a specific submission to the effect that we have got a rule. That rule covers that the contractual employees have to be if any punitive action is taken against.
No, actually, it's not exactly. I don't think they will take that stand of punitive action, because I asked you that also. When you opened your argument, when you opened that opportunity of hearing in punitive thing, so that was, and then I asked you regarding the service conditions, service rules, all these things. Because your case is that they are not disputing that it is pursuant to that direction by the director. Director order ta author dekhibe jodi mass strike upare jota aichi.
Yes.
On ebe dekhu nathile. Just look at
Sir, it Annexure 2 re achi. Sei anusare se mate terminate karne.
So there was a strike. So nobody was coming. You had to join on 5/12. You met with an accident.
Sir.
So that is how I am asking him to, how do you say after 3/12? 3/12, if somebody, kindly sit down to see how the things are unfolding. Yes. Let him say so that you will respond. Yes, you are disputing that medical report.
Para 8 of my counter, page 3. I am stating that not received, that Avron made in para 4, that is Annexure 3.
No, OP number 5, it doesn't help.
Not received, petition.
OP number 5, who is OP 5?
That is collector.
So that is not, that doesn't suffice.
Here is a case, Millers, on basis
Mr. Mahanti, if you disown the BDO or the collector or the clerk, then it becomes very difficult.
On basis of the agreement.
Now you can start a DP against that BDO who has not intimated.
On basis of the agreement, he has been engaged. Your lordship see that para Annexure A/1, Lord's A/5, page 9 of my counter.
Yes.
Then turn to page 11 of my counter.
No. Then look at Annexure 2. Look at Annexure 2.
That's why Annexure 2 is the mass strike.
No. Look at read it. Please kindly read it.
I'll read.
In view of the above,
Annexure 2, page 13.
Correct, 16.
Page 16.
Annexure 2 is 16. Apanko page 13.
Annexure 2.
Mana bhul bhal hochi ki?
Yes.
Dated 3/12/16.
In view of the above, if computer programmer do not report to their duty on or before 5th December 2016, you hereby direct to terminate the service with immediate effect.
So you are not referring to the agreement. The problem is that Annexure 3, Annexure 2 has resulted in his removal.
Yes.
Then mark copy to carbon copy to CC, carbon copy
CC.
or Chichi as they say in
Private Secretary, Honorable Minister.
Read the last one, 3/4.
All videos, informations.
Yes. So in fact, you also intended that the video will disengage him if he doesn't report to you.
That is not
So now you cannot resort back to the agreement and all these things. Because your disengagement is on basis of Annexure 2. Directing that if it, because they are under strike, they are not listening. Fair enough. Fair enough.
Lordship, see that agreement. Lordship.
No. Then you go back to agreement, but you follow first. Explain first Annexure 2.
Yes.
Then your averment in counter denying.
That is Annexure 3.
Annexure 3. Interesting is that you do not deny that it was it was received by the video. That's the first thing.
That is.
He never sent it to video. He sends a mail.
That averment is absent in my counter. That is.
No. You fairly have placed that paragraph. Yes. I mean, it's not. Obviously, what is there on record, it is on record.
Yes.
Then how do you deal with Annexure 2 in your counter? The next point. Look at please paragraph 9, page 3.
I am reading that paragraph 9.
Yes. No, I mean, no, you take your time.
Yes, no. I have. It is humble submitted that as per the direction communicated, by letter number 22619 dated 3/12/2016, issued by the government in Panchayat Raj Department, the disengagement order was passed by such and such on 13/1.
So there is a comma missing. That's not a mistake.
Yes.
Panchayat Raj Department, there should be a comma, I think. There should be a punctuation.
That is a comma.
Because the disengagement, if you read Panchayat Raj Department disengagement, that's not.
No.
Yes.
It's a comma. The disengagement order was passed by order number 201/16 dated 13/1/2017 by the collector Kandhamar.
So, Mr. Mahanti, you could have disengaged him on the basis of an agreement. That could have been a better argument on your behalf.
Yes.
But you explain paragraph, Annexure 2 is not, it cannot be denied. First of all, you rather rely on Annexure 2.
Because not received that.
No. Annexure 2 is your director. You just look at,
right.
Just mark that date for what you have read in paragraph 9. Communicated. You check it. I think that is what is Annexure. Yes, 13/1/17.
Yes.
13/1/17, 201-216, the same. Yes. Page 20.
Yes.
You are page 20, 201/216.
Right.
Director 13/1/17.
My lord.
So that is so you have stated correctly that.
Yes.
So after that, then how can you now refer and say that the contract, because he is supposed to be not disobedient. In fact, I was asking in those lines only that if you commit something or something then which the employer doesn't like, they could disengage. Then you enter into an agreement. But here is a peculiar thing that you say that yes, we followed Annexure 2 13/1/17.
Yes.
And regarding you have denied, yes, you have denied that his letter, but in a very strange way. He sends it to video. You say collector never received it.
Because collector
And Annexure 2 in para 9 is addressed to collector or video.
Annexure 2 para 9.
Please. Para 9 of your counter. I'm sorry. Annexure 2 referred in para 9. Look at page 20.
Yes.
Four.
Page 20.
Page 20. I'm sorry. Page 16. Page 16.
All collector.
Look at 4. Carbon copy. Same, sir. Not 4. Page 16.
Yes. For to all video.
All videos. The video is also aware of this.
Yeah, maybe aware of this.
So-
but he has no
so,
power to terminate
so-
the. He has no power to terminate or.
Whoever has exercised
or
the power,
or
if the
allow-
video,
because
if the video has shown dereliction of duty of not entertaining a leave application was met with an accident, which is not disputed actually. You have denied him in a different way that we have not received the email. But if you look at that document which has been annexed showing his dislocation of his shoulder, that clinches. Mark the registration because it is a government form.
it's a government hospital.
Form is also government. This is not any kind of a prescription to be issued by any. Can mark the registration date 32786512616. When you said that we are disputing, I was thinking that you may dispute this. Mark the registration number 211766 something. Say again kati jaichi tara.
It's an outdoor patient.
766 something gote kati jaichi amar margin re सब kati jauchi. At the top.
Ticket. It's an outdoor ticket.
Yes, OPD card number 03 orthopedic. It has been registered 32786 5216. Registration number is there. And kindly mark the diagnosis.
So I'll take instruction on that from that.
No further instruction because you have not.
Because
I think. I mean, maybe you have taken a fair stand that you did not challenge. You have not challenged 18 and all these things. So there's no point. So after recess, I will complete the dictation.
No, my case.
Any difficulty, Mr. Das?
No,
My
because
case-
I will just hand over that rule. I want to.
No, I'm not going into that rule.
Okay.
Don't invite
case-
examination of that
Okay.
rule. If you invite examination,
No,
then
no.
you have to maybe make.
I shall be bowed down, whatever.
No. Why should you? You are holding a brief.
Yes.
Maybe then you have to listen to Mr. Mohanty's argument on agreement.
Yes.
My case is that Miller's he's supposed to join in a transport place because he has been transferred to
That is-
Hon'Ble.
Once you, in paragraph 9 of your counter, correctly state that yes, he was disengaged for non-joining, that clinches the issue. Thereafter, you may throw him or you may like him. That's another
Concerned
issue.
authority is the collector, Miller's.
Doesn't matter. Somebody sending this email to BDO Cuttack
Yes.
or BDO is different. But the thing is that annexer, BDO is not the authority to grant. That's fine.
That part I will confirm Miller's whether video has received or not. That is
No. After counter, I cannot reopen this.
Yes.
I should not also. Why should I? I'm not conducting a hard-hitting inquiry to find out. You have
I'll
stated.
take instructions short that maybe.
No further because we have spent enough time. The matter is pending since
it's a
last
case of
8 years. You should be happy that you have finished it in 8 years
Miller.
and you have done your best.
It's a case of Miller's contractual appointment with a
That part I told you that he also knows.
44 days below. So he has no right to continue even if
No.
renewal is not
Here it is annual. Here, whatever consequences will follow, that is to follow. Because that is not his prayer. Why should you bother about that also? By setting aside that order of non-joining on 5/12/2016, whatever consequence he will face it. He's not challenged.
He has
Like
not-
the other matter, Mr. Biswal.
Ultimately, he has not disputed that he was not in strike.
No.
Because it's a mass strike.
You see that there has been a lot of discussion regarding his disengagement. He was disengaged 4 times, reinstated 4 times. 5th time in January he has been disengaged. It's not 44 days, it is 1 year.
Yes.
1 year engagement.
1 year, yes.
1 year engagement ends
One day
of
break.
February 28, starts on 1st March. You keep that whatever rules you are saying, keep ready. Just ready. If possible, then I'll look because I don't think it is required. So after recess, dictation then sorry one. Any mention? Upon page 18 tabhi dekha. In your brief, also find out page 18.
Yes.
रखतान से इधर सीधे इट रखो ऊपर रखो सार को ब्रीफ टाणी भी रखता है कितना पेज जो देखा जाओ यस मेंशन सर
item 21 में
yes
That case, my lord, I am for the petitioner. The counter has been filed by the government, and they were supposed to give a copy to the petitioner as well as the opposite party, other opposite party. Last occasion also, they have taken the time to give the counter copy.
I have the copy. Right now, I am serving. I have got the extra copy. I'll give it right now.
Mr. Prashant Kumar Ponda for the petitioner. Mr. Prabhu Prasanna Behra. You have to please Prabhu to get things. So that is the problem, perhaps. He is not, when Prabhu is not displeased, then how can you get it? Mr. Prashant Kumar Ponda for the petitioner. Mr. Prabhu Prasanna Behra, additional standing counsel. For the OP number 1, Mr. Baidhara Sahoo.
OP number 2, my lord.
Baidhara Sahoo, OP number 2. OP number 2 to Mundakil. You still have objection or what?
No, more objection.
So Baidhara Sahoo for OP number 2. The learned counsel for the petitioner submits that the copy of the counter filed by the OP number 1 state has not been served. Number 1, register cooperative society. Register cooperative society has not been served. Mr. Ponda, you have received the counter filed by Mr. Sahoo?
Yes.
What counter file?
The learned AC shall serve a copy.
Yes, in course of the day. Right now, I'm giving it.
So submits that he shall, the learned AC in response submits that he will serve copy during course of the day. When do you want, sir? केबे चाहूँ
Any day.
After vacation हो sir.
Vacation बहुत दूर है.
आप केबे चाहूँ?
Before vacation and date your lordship's convenient.
Suggested date, Mr. Sahoo. ଆପଣ ଯଦି ମାଗୁଛନ୍ତି ଆପଣ ସଜେଷ୍ଟ କରନ୍ତୁ. Agree for a date, sir.
25 ଜୁନ ହେଇଯାଉ 25 ଜୁନ କରିବେ ତ 25 ଜୁନ after vacation.
ଗୋଟେ ଚାନ୍ସ ନଉନାହାନ୍ତି ଗୋଟେ.
ହଁ sir, any date ପାଇଁ.
Any date କିନ୍ତୁ ନାହିଁ ନା ତା ଦେହରେ. Dates are only from 24th to 16th.
और सर 15 था 15 में
16 तो रखिदेवे सरला कर 16 तो से कोट हवार नहीं 14 रखंतु
हां सर
but he notes your
हां sir
I mean anxiety that it should be go after vacation से दिन फिर अर्जन करिवे कोन give him that chance list on consent list on 14 5 20 25
oblige
yes so after recess
sir
yes, I'll be dictating this. Any mentions? Anyone waiting for any? Yes, please, Mr. Mahanti. Subuni. Take a sound at the end.
And he has stated in para 8 that he has not received that. I am sorry for that.
No, that is the problem with email.
He has said that I have not received.
That's the problem with email. Registered post, CPC. Email, just see that. Look at that email.
But
kindly look at that email.
I have seen that email, but whether delivered or not, it is not written. Obviously,
the video has to say that it was sent. It was not sent in my email ID. To deny email,
he has written that not received.
That's the problem. That is emails are not letters to be said that whether received or not received. In fact, that is how it has led to led to a lot of controversy.
I understood that position.
Sorry,
I understood that, but whether it is
WhatsApp, double tick, also all those things.
Tick is
so there are two views actually. Since these methods of electronic communication does not take into account once it is sent, it is sent. What is that?
WhatsApp
What is
message
that
is-
decision, Mister? That
WhatsApp message is
that
excluded now.
contract act decision. As far as the sender is concerned, it is sufficient when the date
When
from
delivered.
Khamgaon to
When it
Ahmedabad.
is delivered.
What is that? That decision is there. Madala 30 or whatever. And as for the recipient, it is that when it is received.
Yes.
The agreement is complete as far as the sender is concerned when
Once
it is sent by post.
contract is completed.
So, but that scenario has changed, and it is similar to also email. So once he has to, if he has stated that it was not sent in my mail, or that is not my mail, then that's another thing.
And another thing, page 15 of my counter.
Let me check that email again. Let us see that email again. Mr. Das, you sit down. You are mentioning something.
Yes, my lord. My lord, item number 29. It was, my lord, urgent in the mentioning time. I am for the opposite party. I am for the opposite party.
Yes.
Only thing I am mentioning that let the matter be before vacation, my lord.
We inform Mr.
Pratik Das on behalf of
Pratik Das. Go to vacation to date kar diyo.
14/5.
I have been repeatedly explaining the learned members that please don't do this in the absence of give either consent or wait. But they are going on mentioning, and you inform अपन भी inform करियो है ना 23/6 है 14/5. Because if I entertain his mention, then I have to entertain your mention also. That is the issue. Say email टा देखिले कितने annexer सेटा?
Annexer 2.
2.
Yes.
The 6. Annexer 2 is that letter from the register.
On page 19 of Lordship.
Page?
Page 19 of the brief.
19.
Yes.
We are looking at which brief?
Page 15 is
This
the
is item?
application, na?
This is which item?
13.
13. Two 6103. Some other brief.
19, that is date has been mentioned.
26103. No, I was looking at some other brief, so that is the difficulty. The hard copy टा देले. Mr. Mahanti, please mark. Alok Kumar Nayak.
Alok Kumar Nayak.
Then below that.
Below that,
Read it. You have to read it for the court and for him to. ORI dash.
Bandha
at nic.in. Ashok Gowda 9 at gmail.com. That is how he has said that it is not my office mail. He has sent it in office mail.
First is the office
nic.in. Second is also Gmail.
Gmail.
That is how he has not said that.
ORI dot. That is a dispute.
ori.nic.in जोटा से कोई से ठीक को ना दे.
ORI dot.
ORI सेटा आपनकर nic.in ठीक अछि. ORI dash tumudi bandha is the first part.
NIC dot.
What he was doing, this fellow was doing, the
And
petitioner.
unable to resume duty,
Computer
please
program.
find attached.
Computer programmer.
You see, he knows what is the email.
Right, that is correct. Another letter, let's see that.
And who is that who has filed the affidavit? Gowda has filed affidavit.
No, another person's.
How can he swear affidavit on behalf of Gowda?
No, he's a block development officer after transfer of that Gowda.
Acha. Bonavir Harpal, son of Fazil Harpal.
Yes.
So that's the other problem.
Right.
Where he has stated, you are saying that he has not received?
Para 8 of the
8.
In the office of...
No, he is or no. He has not written email even. even letter. Yes, no such leave application. He doesn't refer to email even. It has been very carefully worded.
And another
You have to be very careful actually. I mean, as far as pleadings are concerned, we interpreting a pleadings because I mean, that will be the defect in the judgment. Yes, he is very careful. No such leave application has ever been received in the office of the opposite party number 5.
Lordship, I have find out the official email. That is PAH.tumudia Tumudibanda at NIC.com in.
He is the computer. He sends those emails.
That is the official email.
No, Mr. Mahanti.
No, I am not.
I mean, Mr. Prabhu, you are making the mistake of finding the email on 24/6. He has to state that on oath that this is not the official email of the video or whoever the addressee, or that of Asoko Gowda. And interesting, he does not even say that no such email was received. He denies that no such leave application was received. And if we ask Gmail, the old letters are there. But anyway, they have to enter into that. He is not entering. He has not said that the Gmail ID is not so and so, so and so.
That is good. But
Neither you have disputed the hospital report, nowhere in the counter affidavit, and wherever you have tried to dispute that because one of the argument is that contract is in terms of the contract, but you have dismissed him, removed from service in terms of that Annexure 3, paragraph 9, what you have stated. That is his case also. That I was after that I could not join on 5/12. This is the reason, and I sent this email. They have not, but still they said that since I have not joined, in fact of not joining is not also disputed. He says that I could not join, but I suffered from fracture.
And it is the OPD ticket, not I think not admitted. Exactly.
No.
Not admitted.
Can you look at left-hand margin? The more you speak on that, more will be a problem. Page 18, OPD ticket, registration, everything is there. Rest to left upper limb for 1 month.
That is written. Left-hand side.
And see the diagnosis at the top. That hash is fracture. Date X-ray date ta kete अछि date agru पडुथिला
12/5 itself 12/5/16
12/5/16
संतोष कुमार डॉक्टर संतोष कुमार साहू बरहमपुर एक्सरे सन डायग्नोसिस लैबोरेटरी डिजीज एक्सरे बरहमपुर
कौन कोजे लिखिथिले आपण the issue boils down to the disengagement of the petitioner by letter dated letter dated 13/1/2017 issued by the collector and chief executive officer district rural development agency Kandhamal. Chief executive officer bracket लिख दियंतु CEO DRDA लिखि देबे district rural development authority बोलते ना authority ना agency under the government of Panchayat Raj department. The It is submitted by the learned counsel for the petitioner that the disengagement of the petitioner, as he did not report to duty on 5th of December 2016. Is the apparent reason as it disclosed in the letter dated 13/1/2017. (13/1, 2017). Was pursuant to, refers to the BDO's block development officer, opinion number so and so, comma, Tumudi Bandha, vide his letter dated 16/12/2016, that after postponement of mass strike by the computer programmers, Sri Alok Kumar Naik, computer programmer, did not report for duty by 5/12/2016. The learned AGA, appearing for the opposite parties, supports the order dated 13/1/2017, inter alia, on the grounds that the petitioner's engagement is a contractual engagement. As per the contract entered into between the employer and the petitioner, that is Annexure 1, in terms of the agreement, which also forms part of the Annexure 1. The learned AG refers to the counter affidavit, particularly in response to the application of the leave application of the application of the petitioner dated 5/12/2016, annexed to the writ petition marked as Annexure 3, also enclosing the outdoor ticket of Maharaj MKCG Medical College and Hospital, Berhampur, which indicates that it was 03 orthopedic, registration number 211-76685, dated 5 December 2016. OPD card number lekhuntu. OPD card number lekhibe. OPD card number 03 orthopedic, OPD card number 211-76685. Page 18 raj. Registration number 0301-3363, dated 5 December 2016. Also, countersigned by the concerned doctor managing the OPD, giving the details of the diagnosis, provisional diagnosis, and also the advice regarding medical examination, further medical advice regarding further medical examination, the medicine to be taken, and also the advice, quote, rest to L upper limb for 1 month. सेंटेंस कौन स्टार्ट करथिले गोटे लाइन पढ़िले स्टार्ट जो करथिले लंडन डीजी Annexure 3 पर स्टॉप कर दियो the said annexure encloses the medical report to the application dated 5/12/2016 and copy of the printout of the email अपन एटा जो लिखि देला परे तापर लिखछन बुझ पल्ले जो डायरेक्टली डिटेल्स and also the and न करी स्टॉप करी लिखंतु the application also encloses printout of the email sent from petitioner's email देखिए लिखिबे आलोक 1 PLB जहाँ लिखिया था लिखिबे to the email ORI dash तुमुड़ी बंध देखिए पूरा लिखिबे पेज 19 and Ashok Gowda. The email also shows the two attachments, that is images in JPG format, that is apparently of the application and the outdoor ticket of the MKCG Medical College as indicated above. The learned counsel, the learned AG refers to paragraph 8 and 9 of the counter. Anything else apart from para 8 and 9?
10 also.
Para 8, 9 and 10. 8, 9, 10. 8, 9, 10. The contentions are?
And 15 also.
The 8, 9, 10 and 15. The contentions of the learned AG, contentions raised by the learned AG can be summarized that as indicated in the counter affidavit, the receipt of the no, that is not your contention because you are simply placing it. Contention काटी दियो perusal of paragraph 8 of the counter affidavit would indicate that the averments made in paragraph 4 of the writ petition regarding forwarding of the leave application, enclosing the OPD ticket as well as the email, are denied. Quote, no such leave application has ever been received in the office of the opposite party number 5. Para. Regarding the receipt of the, whether the email was received, whether the email ID is correct, have conspicuously not been mentioned or disputed in the answer. The denial is regarding receipt of the leave application. And in fact, without any statement regarding the email in response to the specific stand of the petitioner. Nothing turns on the averment of the opposite party. Number 5, that the application was not received. The leave application was not received. Paragraph 9 of the counter affidavit indicates that the disengagement was pursuant to the letter dated 3/12/2016 passed by the direct OP number so and so into bracket annexer 2. Further, paragraph 10 of the counter affidavit goes to show that the disengagement order was issued on 13/1/2017, referring to the order of the Director Panchayat Raj dated 3/12/2016, no postponement of the mass strike by the computer programmers and resumption of duty on 5/12/2016. In view of the above, it has to be held that the disengagement of the petitioner was attributed to his not joining duty on 5/12/2016, which is also the clear stand of the opposite party in paragraph 9, and also the reasoning in the order dated 13/1/2017 of the collector and CEO. The learned AGA then admits that collector had disengaged the petitioner and he was not disengaged by the block development officer. Para. The argument is, should I reflect that he should have written to the collector or not necessary? Apparently, the order dated 13/1/2007 issued by the collector and CEO refers to the report of the block development officer that the petitioner did not join duty on 5/12/2016.
And due to his prolonged
Suvilan.
due to his prolonged absence, written that letter. Annexer B/2 page.
Prolonged absence ହେଇଥିଲେ ତ ଭଲ ହେଇଥାନ୍ତା.
ଲେଖା ହେଇଛି ସେଠି।
No.
ନାଇଁ,
First paragraph ପଢନ୍ତୁ.
The lordship for the page 15 of my count.
No, 20. ମୁଁ original order ଟା ଦେଖୁଛି. I am not adding anything. Look at the order impugned at page 20. 13/1/17.
Yes.
First paragraph. Just read it. Whereas it has been reported.
Whereas it has been reported by the block development officer.
Tumudi Bandha.
Tumudi Diga Bhait letter number 2275 dated 6/12/2016 that after postponement of mass strike by the computer programmer C. Alok Kumar Naik, computer program of Tumudi block did not report for a duty by 5/12/2016.
So he doesn't refer to anything else.
But in its report that is written.
No, the collector's order, because I can't, the same, this.
Collector refer the
That Gordon Das Bhanji. The orders are not old wines that will mature in, so I cannot, or you can, in argument, you can develop, the court also cannot add those things. Then look at para 2 also, nowhere.
He has referred the report dated 1612.
Correct. Then read sub paragraph and whereas. What is his reasons? He has given it.
It has been instructed by the government of Panchayat Raj Department of Odisha by letter number such and such, terminate the service of the computer program who do not report their duty on 5/12.
Yes.
That is the reason. And only refer to that letter.
Then
Annexer B by 2.
Then kindly mark the sub para 3. Now therefore,
after careful observation of above irregularity, it is inclined to believe that C. Alok Kumar Nayak does not deserve to be in public service, and as such, the undersigned hereby disengage the said Alok Kumar Nayak, computer programmer of the Tumultia block, from
yes,
contractual engagement with immediate effect.
So to add to that, whether he was absent or not, or what, whether, because his case is that I did not join on 5/12/2016. That is his case also. It's not that he's denying that. Did not join on 5/12/2016. After the resumption of work as the mass strike by the computer programmers was postponed. Further, it referred to the government in Panchayat Raj Department letter dated 3/12/2016 into bracket annexer 2, which had provided page 16 in view of the above, if the computer programmers do not report, ends at with immediate effect. But the letter as at letter dated, the said letter of the government dated 3/12/2016 was addressed to all the collectors with copies to all the videos for information and necessary action. As a result of which, the video following that letter had issued the report to the collector on what video report enclosed Mr. Mahanti? On 6/12/2016,
Annexer B
enclosed to the counter marked as Annexer B by 5.
B by 5, page 15.
The said letter indicates the following in inviting reference at a page 49, Raj. In inviting reference to letter on so and so, not reported up to working season working season. Para. Since the absence from duty on 5/12/2016 is also the case of the petitioner. Now it remains to be seen whether he had any such reason to remain absent and whether the reasons are justifiable. And lastly, whether the authorities, while passing the order, have dealt with the said aspect. Para. Since the authorities deny that they did not receive the application of the petitioner seeking leave along with seeking leave dated 5/12/16, Annexure 3, along with the outdoor ticket of the MPCG Medical College, which contains details of the treatment, provisional diagnosis, further advice, and the email dated 5 December 2016, sent at 2.03 hours, 14.03 hours by Gmail with subject unable to resume duty. Address to, what is the name of the petitioner? Yes, address to the email IDs. So देखिए लिखिए along with the two attachments. That is the OPD outdoor ticket, outpatients department ticket, OPD ticket, and the leave application. In considered opinion of this court, the petitioner had just and sufficient reasons, having suffered fracture of lateral end of clavicle. Clavicle spelling देखिए लिखिए, clavicle into bracket left. And further advised rest to left upper limb for 1 month. Sentence had sufficient reasons on medical grounds to remain on leave with effect from 5/12/2016 till he joined his service on 13/1/2017. ना केबे गोटे लिखुछंती आपण केबे गले कौन कहले सुबिलानी?
No, I am not saying. No, I told that the file is there, so I don't have the.
Oh, अच्छा अच्छा. Sorry. आपण फाइल टा.
Yes.
Para 4 रे लिख.
आपण केबे कहउछंती गोटे?
आगे.
से केबे जॉइन कले बोली कहउछंती आपण गोटे कोन से गले और टिल ही रिपोर्टेड ऑन 13/1/17 ना कोन कहउछंती?
No.
नहीं से गले 5/12 रे गले सेही दिन एक्सीडेंट है लिखि छन.
से तो से एक्सीडेंट हे गला. ता परे जो से आपण गोटे सर्व कले ये कले कहउछंती सेटा
20 केते उडा अछि बोले. एते अछि.
Anyway, that's not relevant.
इनकरी हां
Yep. Very good.
21/17
सेटा कोड लिखुछंती?
It's a B C/2.
आगे
C/5. That is para 10.
कौन लिखले? सेंटेंस आफ्टर ले टिल जॉइन काटी दियंतु ता टिल पूर्व पढंतु टिल टू काटी दियंतु. As the events have unfolded thereafter, the disengagement order was issued on 13/1/2017, which has been served by the process server
121.
on 20/1/2017.
Same has been refused by the petitioner.
As contended by the opposite party, referring to the letter dated 13/1/2017 issued by the PD-DRDA. এটা কি ইস্যୁ କଲେ ଯୋଉ ଆପଣଙ୍କର ପେଜ 15 ଟା ସେ ତ ଭିଡିଓ ଲେଖା ହେଇଛି
ଭିଡିଓ ଏଠି ଇନକ୍ୱାରି ରିପୋର୍ଟ ଦେଲେ କଲେକ୍ଟିଭ
ନେ ଆଦେଶକୁ ଯୋଉ ଲେଖା ହେଲା ସେଟା କଣ ମେମୋଟା କଣ ମ୍ୟାଚ୍ କରୁନି look at page 16
1317 that is termination letter 13170
ହଁ ଯେ ବଟ୍ ତାର ଫାର୍ଷ୍ଟ ପେଜ ଟା କାଇଁ ଫାର୍ଷ୍ଟ ପେଜ ଟା ମିଶୁନି पेज 16 ର ଫାର୍ଷ୍ଟ ପେଜ କୋଉଟା ହବ ଓ 50 योर पेज ମାନେ ଆପଣଙ୍କର ଇଣ୍ଟରନାଲ ପେଜ 16 ରନିଂ ପେଜ 50 ଆନେକ୍ସର C/5
first page
ମିଳୁନି କଣ ଲେଖିଲେ କୋଉଠି କନକ୍ଲୁଡ କଲେ ସେଠି ଖାଲି ପଢ later date लिखोतु what later referring to the document marked to the writ petition counter document marked to the counter affidavit marked as C/5 which contains endorsement in Oriya
yes
सहर्षई पे कौन कहले सुमहांती
ଆଜ୍ଞା
उक्त आदेश को सीपी सरे हर्षई तालबेस हर्षई परे हर्षई कौन हेतु कहले
सी हवा କଥା
सी होची कंप्यूटर
हां सीपी कंप्यूटर
प्रोग्रामर तो ओडिया लिखा हला सीपी
सीपी आलोक
सी फॉर सरे हर्षई
सीपी
कौन लिखले ओडिया that made by the server that was served on the petitioner para in view of the finding that the petitioner had sufficient reasons on medical ground not to resume his service not to join in service on 5/12/2016 due to his injury as indicated from the medical report from the document from the OPD ticket of the NKCG Medical College at Berhampur the order dated 31/1/2017 is set aside. The writ petition is accordingly allowed. Our prayer कौन अच्छी 6 भी 6 करचोंदी
Was the order annexer 4 and 6?
The annexer 6 being a consequence having been issued in with reference to the 5 December 2016 order refusing the representation of the petitioner to re-engage him is also set aside. The annexer 6 dated 70 stop para कर लिखी दियो तो बस सेते सब para कर दियो तो आउटे in view of the setting aside of the annexers dated 13 month the orders dated 13 month 2017 the consequential order dated 17/6/2017 if the petitioner is so advised if makes any application for re-engagement the same shall be considered without in any way influenced with the earlier orders which have already been set aside by this order or this judgment court. Yes. The writ petition is allowed and disposed of. So last year, yes. Thank you, Mr. Mahanti and Mr. Das. You have concluded a 2017 matter. We have taken exactly 7 years. 7 years, some months. 25 January 2018. No, के 25 ना कौन लिखा है ची नहीं नहीं सॉरी वो 13 बार 17 फाइल है अच्छा it is about अच्छा आप इटा उटा कौन लागी ची कौन है रिसीट टाको कौन ऊपर लगाइले अठा मार देले तो गुंथिबे ना कौन जीपीओ माने एटा हाई कोर्ट रे ना कौन ना आउ का रिसीट आसे लगाइ वो सार को रिसीट लग लगी तो सार फेरन So that's some receipt actually got stuck in the court brief. Yes, next. Mr. R.K. Samal for the petitioner. Mr. Santosh Kumar Nanda. Adjournments. No brief is pulled out. Without orders, there is no adjournment. There will be an order. Mr. R.K. Samal for the petitioner, Mr. Santosh Kumar Nanda for the opposite party. The learned counsel for the petitioner seeks accommodation in absence of the learned arguing counsel on consent list on 14/5/2025.
15.
Mr. P.K. Behra for the petitioner, Mr. Ambika Prasad Misra for the opposite party. The learned counsel for the petitioner seeks accommodation due to personal difficulty. In personal difficulty, in absence of the learned arguing counsel. On consent list on 24/6/2025. 15 sub item 7215. Same order.
16.
Mr.
16, sir. Before going to my learning senior managers, I pray one things. In this case, what happened during pendency of the writ application matters? He has challenged initially. He has challenged the very initiation of disciplinary.
Why you are tilting towards him? You tilt towards the microphone. Yes.
My learning senior initially challenged the disciplinary proceeding matters.
Correct.
During pendency,
the punishment has been awarded.
Without preferring the appeal, he amended the same and before your lordships. My humble prayer before your lordship. In that case, my lords, one additional affidavit, additional counter affidavit has been filed by the bank authority. But that has not available in my brief, my lords. I pray to reconstitute the same. And
my lord, in response to that additional affidavit, I have and the counter earlier filed by the bank, I had filed my rejoinder. And the copy has been supplied.
Yes.
Now he's saying that because of the change of counsel of the bank, he doesn't have a copy of the additional counter.
No, that he's not saying.
He's saying that.
No, last part is most crucial. You have missed it.
Which one?
He said reconstitute. He never said that Mr. Chinchani may serve with copy. He simply said that there is his. No, it is actually he's just endorsing that it was filed.
No.
He says that additional affidavit has been filed, which is not with me. I may be allowed time to reconstruct my brief.
That is my prayer.
Or I have heard wrong.
So let it be taken up on 5th May then, my lord. Because it is of 2018. And
since that is a statutory remedy of appeal, my lord senior has not availed the same.
My lord,
and directly filed this before you.
I have challenged the impugned order on a substantial ground that they don't have any jurisdiction to initiate departmental proceeding. Because 6 months after my retirement, they cannot even proceed with the inquiry, departmental inquiry. That is the regulation of the bank. and it is being supported by the full the three-member bench of the Honorable Apex Court. By considering the perimeter provision, they have come to that conclusion. If your lordship knows that departmental proceeding starts with the issuance of charge sheet, merely because something has happened, they can't say, and later on they can.
No, Mr. Chinchani, it is not in all cases that departmental proceeding cannot be initiated. It can be initiated like OCS pension
it is a
rules.
bank regulation. It is governed by the regulation.
Correct. So there can be a blanket, but you are saying that the all rules provides that there can't be.
Yes.
OCS pension, the civil service pension rule provides that.
That is
4 years. Rule 7. Rule 7, Rule 6.
Dispute about that.
Correct.
But the regulation here.
So let him construct his brief. Mr. PC Chinchani for the petitioner. Now, Mr. Who is appearing for the bank?
I am for the bank.
Mr. Kabir Kumar Jena.
Minors.
Earlier, Hemanta Kumar Mishra, no more.
No more minors.
Mr. Kabir Kumar Jena for the opposite party. It is submitted by the learned counsel, Mr. Jena, appearing for the opposite party, that the opposite party bank has obtained a change of counsel with consent of the learned counsel who was appearing earlier. Name of Mr. Hemanta Kumar Mishra and associates who had appeared earlier for the bank shall be deleted from the cause list as well as the case brief. From the next listing. Para. It is submitted by Mr. Jena that since the brief has been transferred to him, he is not in possession of all the pleadings and may be accommodated to reconstruct the brief. Yes, Mr. Jena, he's seeking time. He's suggesting for 5th of May. What do you say?
Minors.
On consent, list on 5th of May 2025. Liberty granted to the learned counsel for the opposite party to obtain copies of the pleadings. Scanned copy from the registry on payment of cost, if any. Yes.
17. Obligement.
Yes, please. Mr. S.K. Tripathi for the petitioner. Yes, Mr. Tripathi.
That the petitioner has before this writ application, my lord, with a prayer to re-verification of his disability percentage, my lord.
Just kindly speak to the microphone, sir. Like both of one can use the other side also. Yes, sir.
For re-verification of his disability percentage.
Yes.
Here is a case, my lord, that the petitioner is applicant for the post of junior assistant.
Yes.
In the category of SC PWD.
Yes.
Person for disability, my lord. That he has successfully completed that, he has qualified in written. Thereafter, my lord, pursuant to order, pursuant to direction, he has also appeared the skill test. There also he has got success. And my lord, he also that the minimum required disability was 40%, my lord. A certificate given by the state, by the district board, my lord, district medical board, that certificate he has submitted before the authority, my lord. But that authority, my lord, after the applicants have been successfully completed the skill test, my lord, they've been asked to appear before the medical board, that is before SCB Medical College and Hospital, my lord. That there the percentage of the petition is found to be that they have stated this 30%, my lord. And therefore, my lord, against that order, I have preferred this application.
Who is appearing for the aims? Mr. Mahanti, A. Mahanti? A. Mahanti?
Aravind Mahanti.
Aravind Mahanti.
Aravind Mahanti. Now, pursuant to order of this Hon'Ble Court, my lord, he has appeared before the aims.
Can you inform Mr. Aravind Mahanti? You inform him. Let us pass it over. Maybe you just wait. You have difficulty, Mr. Tripathi.
If lordship will call it any other day, it will be better because.
So just
next week.
Just keep. Prabhu has gone searching for Mr. Aravinda. So just give him chance.
ସରକାରୀ ଓକିଲ ଆଉ କୋଉ କୋର୍ଟରେ ଥିବେ
70.
You have copy of that complaints affidavit at flag K?
The report of the AIMS pilot.
Correct.
Yes, pilot, that copy is also sought on me. There the percentage is 60% disability. And the required percentage is 40%. The district board given me 40%.
So what is the requirement?
Requirement is 40%. My certificate was also given, the certificate is given by the district board, it was 40%. But when I appealed before the medical board, that is in SCB Medical College, you know, that has been reduced to 30%. Now the M says it is 60%.
% temporary for a year.
Yes, Mr. Mahanti?
He has written that 60% temporary for a year.
No, before that you must read, sir. On examination, the visual acuity was no perception of light in the right eye. And best corrected visual acuity with standard correction 6/24 for distance and N10 for near left eye. Complete blind in right eye, left eye N10, and that is to also 6/24.
There is a scope of.
By use of specs, we are having 6/6 vision. Some of us are having 6/4 vision, pilot. That is called pilot vision. That those last 3 lines. But he has lost it completely. But I was looking at the report, your treatment. Comprehensive eye examination, wooden trauma with wood stick 5 years back. External adenoxia. So it was why you were hit with a stick for getting employment.
Pardon?
No, please don't take it otherwise, because I am not supposed to discuss on that. Then, Mr. Mahanti, the next, after just Professor Pariza's report, the next page you see, the diagram is there. So left complete opaque, right 60%. Now, what is the dispute actually? I could not understand also. But they are refusing employment.
Yes, my lord.
For what? On what ground? That your vision is all right or what?
No, that state board given me 40%. They require for 40%. I have given that certificate, my lord. But while pursuant to order of the
which one is disputed?
Lord, my lord. Pursuant to order of the authority, my lord, when you have appeared before the
No. Don't go in a flow. Please try to concentrate on the case.
Lordship.
This particular dispute is arising. Which one is disputed by the authority? Which report? They are saying it is 40% is not correct. The CU medical board is not correct.
No, they are saying this 40% is not correct because the medical board is stated that I am having 30% disability.
Which medical board?
STB medical board. Because
then you said 40% on what basis?
District medical board. That annexure, lordship, can have a glance. Take a child now. That annexure, my lord.
Correct. I got it. Yes. Mr. Naik, you be seated. Don't exchange your places. Yes. No, that place is to be sorted out actually. It creates a lot of fear. So, Mr. Naik, you are the answering respondent.
Yes. Yes, Lord. The prayer is already allowed by the order dated 18/6.
Acha.
If
So in fact, I am correct. Right? There is no dispute now.
But
You are not arguing. So your re-verification has been made?
But if that be the fact, my lord, while this honorable court has passed such an order, an interim order has also been passed that any appointment shall be subject to result of the writ application.
Why you are tilting towards Naik? You come this side. You come towards your right. In discussing right eye and left eye, you are changing, both are changing.
Any appointment shall be subject to result of the writ application. But my lord, in the meantime,
we have gone ahead. Mr. Naik is pointing to prayer. Look at prayer. To page 4 of your brief.
That have stated for re-verification.
So let's go over. So the writ petition is disposed of. Now you are saying what would either of you has anything to state regarding this AIMS medical report?
The AIMS part is concerned that
you cannot say anything, Mr. Naik.
No, my lord, see the re-verification already order and that has been executed. But no more prayer is
correct, sir. So that is how I have caught shot, Mr. Tripathi.
Yes,
so after your submission only that you brought to the notice.
Yes.
Now the post maybe it has a bearing on the future of this case.
Yes, my lord.
Regarding the medical report of the AIMS.
Yes, my lord.
You will abide by the medical report. He says he will abide.
Yes.
No difficulty there.
No, my lord.
So only thing is that the AIMS, Mr. Mahanti, can you just talk to him? He's no more holding the brief. After joining
He's not a party to this case, but since the order was to the AIMS director to examine and for re-verification, that's why he was called for.
I understand.
Yes, ma'am.
But this case has to be disposed of on the basis of that report.
Yes, ma'am.
So the dispute is closed as far as the report is concerned for all times to come.
Yes.
And here my humble submission, my lord, that yes, I am also not disputing that report. And if lordship will dispose of that application by giving a direction to the authority to let that the applicant's appointment shall be considered basing upon that report, my lord. Because here
kindly look at the prayer.
Prayer, my lord, that my prayer was that I do admit, my lord. But and or is there if lordship will extend that.
So why should you then what would happen? They will object. Then Mr. Mahanti will jump into the fray. So why you are going on? You don't go there.
Because I am having that the required qualification, though I have got, my lord, but I have been debarred from getting that job. And
what is the interim order you are referring?
Interim order, my lord, that this honorable court has directed any appointment shall be subject to result of the writ application. But
so that observation I will make.
No,
I will simply say that this interim order, since that you see.
No, but during
Mr. Tripathi, the problem is that once you don't file a writ petition making a prayer and you seek a order, which writ petition will be allowed or which will be considered?
But here, my lord, during the application, another person who is not an applicant therein, he has been appointed.
Would be now. This is the situation: is that you have not challenged the appointment, nor there is a writ petition. How? What is the scope of passing an order?
His appointment, I have got no opportunity to challenge because my disability certificate.
Which interim order you are referring?
Lordship, can I have a glance to
3718, my lord. Order number 5.
Order number 5. What happened to Mr. Mahanti, Mr. Prabhu?
He's coming.
He will come.
He is coming. He was in the first floor. He was.
So no, he need not be in a hurry because there is no dispute regarding acceptability of that report. So he has done his part. So I'll mark his presence if he's coming. Yes.
Basing upon the report, let the authority take a decision around that.
No, kindly mark that interim order. Any appointment to the post of junior assistant, SC person with disability, Paradip Portster shall be subject to result of the writ petition. But the prayer, there is nothing regarding that appointment. Nothing is there in the writ petition. Nothing is there. What can be done? WC item 17. So Susanta Kumar Tripathi for the petitioner, Mr. Prasanta Kumar Naik for the opposite party. The writ petition is filed by the petitioner who was applicant for junior assistant in the category of scheduled caste into bracket persons with disability, seeking a direction for re-verification of his disability percentage. Para. Pursuant to the advertisement dated pursuant to the advertisement made by the opposite party authority, the petitioner applied, his candidature was accepted by the authority on 16 October 2017. The authority issued a letter directing the petitioner to attend skill test on 29/10/2017. That 16/10/17 जोटा लिखले नहीं की ब्रैकेट annexure 1 लिखिए. As the petitioner qualified, as the petitioner succeeded in the qualifying skill test, a letter dated 12 January 2018 was issued by the opposite party number 2 for genuineness of disability of candidate by Appellate Medical Board at SCB MCH Cuttack on 18/1/2018 in the I department. Mr. Mahanti,
Yes, Mr.
My lord, I may wish.
you have filed that flag K, that is on that so that
Report.
process has been completed,
Okay.
and they will abide by the report whatever you have furnished.
Okay.
So that is the short compass of your presence.
Okay.
So your presence is noted.
Right.
Appearance like Mr. Aravindo Mahanti for All India Institute of Medical Sciences, because you are not a opposite party, but
Not only because the report
the
was called for
court
that we are
directed.
not-
Yes.
I am
Yes.
for the OP number 1.
Mr. Devaraj Mahanti, UP number 1. Mr. P.K. Naik hochandi UP number 2. Mr. Aravindo Mahanti, All India Institute of Medical Sciences, Bhubaneswar. Mr. Mahanti, you are free. You are free.
Okay.
Because if they would have raised any issue regarding the report, then your presence should have been. Yes. Thank you.
Problem.
कौन लिख ले? এটা জজমেন্ট ফরম্যাটে করে দেবে, টাইপ করে জজমেন্ট ফরম্যাট. At SCB Medical College and Hospital, Cuttack, in the I department. There happens to be a difference between the opinion of the District Medical Board and the Appellate Medical Board at SCB MCH, I department, postgraduate I department. The District Medical Board at Jagat Singhpur has referred to the disability to be, speed I'll slow down. The level of has referred to the disability, that is the level of vision impairment to be 40%, whereas the Appellate Medical Board has referred to the level of vision impairment to be 40%. Being 40% visually impaired, the petitioner, as per the statute and the advertisement made by the OP number 2, is eligible.
The appellate board 30%. Appellate board 30% is reduced it to 30%.
मोटा डाक देली
40 डाक देली
40 देला मेडिकल
डिस्ट्रिक्ट होची डिस्ट्रिक्ट कहले 40, appellate SCB कहले 30. आपण जो एते थोर एपट सेपट हेले से हबो से आपण स्टार्ट कले फ्रॉम द राइट went to the left. Mr. Mahanti has come in between and he has come to the other side. Joined Mr. Mahanti. Devaraj Mahanti. और लिखले ठीक अछि आपण डिस्ट्रिक्ट कर दियंतु साइड रे 30 लिखि दियंतु डिस्ट्रिक्ट 40 फिर भूल हैला डिस्ट्रिक्ट 40 अपलेट 30 हैला is eligible by applying the criteria of जो WD जोटा सेटा persons of disability in the category of scheduled caste. Scheduled caste SC. PWD रे भी आपनकर अछि माने vertical SC ST general सबुथिरे PWD माने it is a across the board para. Considering the prayer of the petitioner and the submissions of the OP number 2,
order number 8
by order dated 18 June 2024, coordinate bench of this court had directed the disability to be decided by the expert ophthalmologist. That is ophthalmologist oblique medical board. Dita conjunction lekha jaichi. Medical board to be constituted by the director AIIMS Bhubaneswar. AIIMS टा full form lekhi ki bracket करते हुए प्रथम जोड़ी लिखिबे short तापरे short चलला Bhubaneswar for checkup and determination of the percentage of visual impairment. Thereafter, by order dated 2/8/2024, at the Lord Council, Mr. Aurobindo Mahanti sought for time for to obtain instruction and file affidavit. Affidavit on behalf of the All India Institute of Medical Sciences has been filed, which forms part of the record, which forms part of the case record. Copy has been served on Mr. Tripathi and Mr. Naik appearing for OP number 2. You are also having the copy of the AIMS report.
I have not reached it, I have seen.
Acha. The learned AGA also refers to the said report as available in the brief marked at flag K. In view of the control, the prayer made in the writ petition for referring the test of disability to a medical board, the affidavit filed on behalf of the AIMS is dealt with in some detail. The paragraph 2 and 3 of the affidavit of the senior administrative officer, affidavit date पकई दियंतु affidavit date केते एटा
13 November
3/11/24 लास्ट पेज रे जोटा अछि
3/11/24
3/11/24 filed on 13/11/24 paragraph कर देबे 2 3 4 5 6. The affidavit encloses the report dated 2nd August 2024 of the professor and head of the department. Department of Ophthalmology, AIIMS, Bhubaneswar. Page रे पाइबे आपण annexure A, flag K. Subject re-examination to नेकी 1 year पर्यंत. The report encloses the outpatient card reprinted into bracket reprinted dated 30 July 24 where regarding of the petitioner who had visited the outpatient department of the Department of Ophthalmology for comprehensive eye examination, trauma with wooden stick 5 years back. The report dated 2/8/24 करंतु. The report dated 2/8/24 indicate complete loss of vision in left eye due to opacity and with visual disability category to be of 60%. Indicating that further indicating that temporary for 1 year quote कर देबे and temporary for 1 year. नहीं आपण सेटा को किछि लेख ताको जहा अछि से कोट करंतु कोन सेंटेंस टिके पढंतु. नहीं आपण सेटा कोट कर दै छन ऊपर यू हैव कोटेड इट ऑलरेडी दरकार ने कोटेस. The loss of vision being 60% in the left eye and complete loss of vision in the right eye. The best corrected visual activity being 6/24. Distance for distance and N10 for near in the left eye, making the disability to be 60% and temporary for 1 year. The said report corroborates the finding of the District Medical Board of the Jagat Singhpur rather the disability as on 30 July 2024 was 30/7/2024 was more than 40%. in the left eye. The right eye, in the right eye, not right, in the right eye, there being no perception of light. Stop. The prayer for the petitioner to re-verification of his disability has been completed by the direction of this court by order dated so and so. ऊपर जोड़ा लिख चल. The writ petition is allowed and disposed of. The authorities, OP number 2 authorities shall act upon the finding of the medical board and report as enclosed to the flag K, copy of which has been as enclosed to the brief marked as first flag K, and act upon the same. The authorities shall also sympathetically consider the fact that the petitioner had appeared and cleared all the examinations for his employment, and at the stage of medical examination, the matter got stuck. How much time, Mr. Naik, to take a decision?
If there is vacancy, then question will come, Lords. That's why Lords should direct to consider.
No. If he has been deprived of, then how can you consider? Then
If
the
there-
result is
if there is
the
no-
High Court participates with you in your nepotism or whatever inefficiency.
No, mind that the appellate court has given such award that 30%.
He had 40%.
No,
You ask him to go to the
not
medical,
he can choose and
the district board.
Also other persons.
District board.
And along with this petitioner, other persons have also appeared, and the
the
certificate was
the
given.
problem is the problem.
And there is no any.
Mr. Naik, please allow me to complete the sentence so that you can focus.
Yes.
Follow the proposition. Suppose the appellate board would have termed him to be Trinetra. Extra one eye is there.
Yes.
What you would have done? You would have disqualified him.
Yes.
Because we required visually impaired. He is Trinetra.
Yes.
He has an extra eye.
Yes.
But ultimately it is found that the medical board has committed a blunder.
Yes.
Then what is to the solution? You will consider.
No,
Suppose you don't give him appointment, or he seeks appointment or for your consideration. Then there can be a direction.
Yes.
But here you have allowed him to intimated. You examined him. He passed the examination. You are not competent to decide his disability. The district board has decided his disability to 40%, and it goes to the SCB medical board, appellate board rather. They say it is 30%.
Yes.
And what about the complete loss of vision in one eye? According to the benchmark disability provided in that PWD Act, what is the consequence of loss of complete vision in one eye?
That's not clear in the statute.
Exactly. So you have also not considered those aspects.
Yes.
And in the PWD quality category,
yes.
In the PWD category, if he has scored ahead of other competitors, then he is deprived of he is discriminated.
No. But I'm suggesting, Lord, my Lordship, direct to consider, and if there is vacancy, Lord.
No, I cannot say that.
Or if some might
see, how can I improve your case?
No,
court.
No, my Lord.
Obviously,
there is no prayer.
So is it your case that since there is no vacancy, we could not give him appointment?
No, that's not.
Yes, exactly. So
presently the vacancy there are or not, I don't know.
He appeared at examination.
I do admit all the facts, Lord.
So
I don't dispute with my Lordship, Lord.
No, how can you dispute? I'm not.
No. The facts, Lord.
You are changing the question actually. There were 5. How many? Then you answer step by step. You can follow it, understand it. How many advertised posts are there for PWD? তাহলে সেটা আপন instruction আনন্তু, you are not sure actually. কোন লিখলে? নাই, the writ petition has to be allowed.
Direct the authority to consider.
Regarding the consequence of the petitioner's disability being approved by the disability found by the district medical board to be correct, found by the authority, found by the medical board of AIMS to be 60% in left eye and complete loss of sight in the right eye. The natural consequence should be, if the petitioner was entitled to get appointment in the PWD category, he has been wrongly deprived of say the appointment. Maybe in fortuitous circumstances. Fortuitous spelling FORTI. তারপর লিখ দেবে ଯୋଉଠି ଆପଣଙ୍କ ଡାଉଟ ହଉନି କି ଗୋଟେ ଦି ଚାରିଟା ୱାର୍ଡ ଲେଖି ଦିଅନ୍ତୁ, ମୋର ବି ମନେ ପଡିବ। ଆପଣ ଯଦି ଚେଞ୍ଜ କରିଦେବେ, ଧରନ୍ତୁ ଏକ୍ସଚେଞ୍ଜ ଟାକୁ ଆପଣ ଲେଖିଦେଲେନି ରିଟ୍ରେଞ୍ଜଡ, ତେଣୁ ସେଟା ସିମିଲାର ୱାର୍ଡ ଲିଟରେ ଦ ହଜବ୍ୟାଣ୍ଡ ହାଜ ରିଟ୍ରେଞ୍ଜ ଦ ୱାଇଫ, ୱାଇଫ ହାଜ ରିଟ୍ରେଞ୍ଜ ଦ ହଜବ୍ୟାଣ୍ଡ, ତେଣୁ ସେମିତି ପ୍ରୋବ୍ଲେମ ହେଇଯାଉଛି। ସେଟା I mean that has been marked by somebody in the YouTube. It was told to me. What is that word? I was thinking that retrenched wife, retrenched husband, that's called representation to be disposed of by the husband, made by the wife. Because retrenched is a very legal word actually. Yes. It is not common use word, no.
Yes.
Estranged is a common word. You don't find, but retrenchment is a very common thing in labor law.
I'm suggesting, my lord.
No, just listen to this. Yes. I understand your difficulty. Maybe that has been created by Mr. Tripathi also. No, he is also ambivalent. He never said in the writ petition, but in the prayer. That I got your point. So I am trying to devise something. Let us take a chance. Just give me complete the order.
Yes.
कौन लिख ले? Wrongly deprived of the said appointment. The learned counsel appearing for the opinion board to in response submits that since the writ petition did not raise a issue regarding appointment, he has no instruction whether there is any vacancy or not. Para. The learned counsel is directed to obtain instruction regarding the number of posts advertised in the SC PWD category. As per the advertisement in question, number of persons engaged, position of merit of the petitioner in the selection process, the subsequent vacancies arising due to retirement or any other reason in the said post. So if you answer this, you get the answer. So I don't have to answer it.
But I was suggesting, my lord, my lordship direct the authority to consider and act upon this judgment.
That is unfair, very unfair. You see some mistake.
No.
It is really unfair.
Authority will.
You see,
authority to consider this.
One writ petition has been heard.
No, my lordship.
I must tell you because there was a writ petition. I still remember. I have sitting here. I have heard somebody said, since I am 60% disabled and the petitioner, the selected candidate is 40% disabled, though I am lower in rank, I should get. So if that is the feeling of a disabled person, then what justice you have done to the
I'm not.
UWD Act creates a right actually.
No, my lordship, I'm not against the appointment.
No. Unless
I want my lordship direct to consider and act upon the judgment.
Thereafter, maybe that I will direct you in view of these details you consider. But leaving the petitioner in the last
stipulated period also, my lordship.
Yes, you get this information.
Okay.
Because you will be then they will be searching for it after he approaches without a court order. At least you have a handle now to ask them. You give me these details.
Yes, yes.
I have not directed anything.
No, no,
But,
yes.
but if you say that I cannot direct to know these details, then that's a different.
No, I'm not.
No, I will answer that. I will answer.
No, no.
That I can answer also.
No.
Fine. I will not hesitate to answer. It is fair for you content any proposition.
Because I am also not disputing and not raising any question on the report also.
No,
And
you
I have not
cannot.
filed it. Yes.
You cannot.
Yes.
I don't know how it happened actually.
Yes.
But the only thing is that whether somebody
Chutti pare as.
Chutti pare niyantu. The entire thing will be lost. List on consent, list on aji kete hela 24 23 ଆପଣ 1 week 24 1 week ହେଲେ 1 ଆପଣ 2 weeks ନିଅନ୍ତୁ. This is an instruction you can obtain in telephone. Because the question is very pointed. Very pointed. ଆପଣ ଯଦି advertisement କରି ନଥାନ୍ତେ ବା ଇଏ କରି ନଥାନ୍ତେ then that's a different.
Legal department ଯାଇକି ଆଣିଲା ବେଳକୁ time ଲାଗୁଛି.
On consent list on 8 5 20 25 to be mentioned. In the category to be mentioned.
15 कर दो ना because से कोन legal लो जाई के आसला लो ठीक है
legal रे एथरे किछ रोल नाही
ना legal पठेइबो तापर आसीबो
सेटा करंतुनी ईमेल जुगरे मिस्टर महांती वाज आर्गुइंग ईमेल पहुंची के नाही से ईमेल जुगरे एडा को करंतुनी. This has nothing to do with any legal vetting or legal. Either you know or not the facts.
Yes.
If I know how to get the instruction also. that I will get.
Okay.
The authority shall provide the instructions to the learned counsel. Failure to do to provide the instruction as directed. The authority shall appear in person to explain the reasons for not providing the instructions. It can be done. I know in one fine morning, the CB Central Board of Chairman CBDT came with the file and appeared in one court.
No, we'll take instruction.
So, there the court's arms should be long.
Yes, yes.
Somebody feeling so great and so big that he doesn't know how many posts are there, how many advertisements is made. So that last line can be the order. I have not passed that order. Because I told you that how to procure the instruction, it can be done.
Correct. That's correct.
So even I can say that he will come in person. The chairman, Paradeep Port Trust, shall come in person to apprise the court regarding these instructions. And that is his first service condition, that he has to abide by court orders. Many times why I gave the example of Chairman CBDT, because he's at the vortex. Many times IRS officers are appointed as directors also.
Yes.
Chairman of court trust.
Once personal appearance is made, so counsel will be there.
No, I said that. No, I have not. I have please, I have not dictated that order. Though in open court, I have said that can be the order.
Yes, that's good.
Last part I have only said that I will definitely, because I am editing all the orders. Be sure of that.
Yes.
There, it is not that I will not know sign and it will go to the registry. Then.
Yes.
18.
Mr. Nayak and Mr. Tripathi, Mr. Mahanti also. Actually, these are the cases where this judicial system is tested. If a physically impaired PWD category person runs around everywhere, that should not happen. Where it should not happen.
All the medical exams revolves around the employment. In this case.
Yes, and the thing is that he should not also run around courts. Again, he will make a comeback and meet Mr. Tripathi. Now, Mr. Tripathi is seriously thinking that the matter should be disposed of. He will file another writ petition.
Court has power to modulate.
Yes.
Mr.
Ponda, there was a mention made by Mr. Nanda. He has some personal difficulty.
Because so many times they have taken the adjournment. Kindly see.
Correct.
So my prayer is.
So I expected this response from you. I asked him for the shortest date. He has agreed for 1st of May.
1st May.
1-5. যদি আপনার কিছু choice থাকে. No, he has a second proposition. Mr. Ponda, he says on 5th May he is not available, or it is convenient to on 1st May he is there.
First May.
Mr. Surendranath Ponda for the petitioner. Mr. Santosh Kumar Nanda for opposite party. The learned counsel for the opposite party seeks adjournment. The learned due to personal difficulty. The learned counsel for the petitioner opposes the same, stating that the petitioners have on several occasions sought for adjournment. No further adjournment should be granted. On consent, acceding to the request of the learned counsel for the opposite party, the matter stands adjourned to 1/5/2025. Yes.
Sure. This is all right.
Yes.
19.
Mr. S.K. Patnaik. Yes, please.
19.
For CGC, Government of India ke naanti? Prabhu, you have left Government of India. Now see the situation. No one is there.
I'll inform.
Mr. Sanjay Kumar Patnaik for the petitioner. Opposite party, none. Mr. Patnaik, when it can be listed?
Next week.
Give a date. Put a date diyantu. Chutti purvaru diyantu sir kହୁchuntu. As prayed for, sorry, कौन लिख ले? हाँ, the learned counsel for the petitioner presses for hearing of the matter. In absence of the opposite party, to give further chance list on 2/5. You have any difficulty on 2/5?
No.
Yes, 2/5/2025. Yes.
Already adjourning the matter.
No. He's saying since no one was there, I was like Mr. DSG along with Mr. Deepak Gochhat. Yes, Mr. Padhi.
File an agenda, we will file an affidavit in this.
You have served. You have been served with agenda.
Yes. They have served the copy. I served by
Mr. appearance Rohila change कर ले. Non करibeni. Mr. Sanjay Patnaik for petitioner. Mr. DSG. Mr. Padhi along with Mr. Deepak Gochhat CGC. Learned DSJ along with the learned CGC appear in VC and address arguments. It is submitted by the learned DSGI that in response to the rejoinder filed by the petitioner in reply to the counter of the opposite parties 4 and 5, he shall seek instruction from the opposite parties and file their response. As when do you want, Mr. Padhi?
After 15 days, 2 weeks after 2 weeks.
To protect 2 weeks after he's saying, I mean, that goes to almost the week before vacation.
5th May, my lord.
He's saying 2 weeks. 2 weeks
after vacation, let's make it.
No, my lord, it's beautiful. They have taken, my lord, so many times time. They are only extending the matter.
He's objecting later.
Convenient to my lord, may fix anything.
12/5 on consent list on 12/5/2025.
Yes.
Instruction, and if so advised, you file your affidavit by that date.
My lord. Yes.
Yes.
Item 20.
May please.
Yes.
Here in this case, the petitioner challenged the non-consideration of his case for promotion, though it has been placed before the DPC to the OFS 1 junior branch.
Yes.
Moreover,
Mr. Das, you require a chart in this, the roster point chart to be prepared.
not
for us.
required, just let me, without opening the brief, I'm just placing
Yes.
what is the case, madam.
Yes.
There are 428 number of sanction posts in the OFS Junior 1, Junior branch, class 1. This is the case for promotion. 250% is promotion, 50% direct recruitment. So 214 posts for these promotees.
Yes.
Out of these promotees, only 5 persons, only 11 persons were there in the position.
Zone of consideration.
No, only in the position, many in position in that cadre. So the balance post was to be filled up. DPC was conducted for these 214 number of posts. But only eligible candidates were 185.
It is entry level of class 1.
Not entry level, but from the promotion to OTAS cadre.
I understand.
Yes.
What is the level of this posting? Because reservation and promotion.
Yes, that is available. That is available.
That is available
yes,
because
the last first grade
lowest rung of class 1 services.
That's there is no dispute about that. So with this process, we have to put 214 in the vacancies. No, sorry, sanction post.
11
vacancies. Only 185 number of persons, eligible persons were there. Because as per the 2011 rules, my lord, eligibility is minimum 6 years service in the lower rank. But because none of the persons were eligible for these 6 years, the government, by exercise of the power of relaxation, they have made it 4 years, so that only 185 persons were made eligible, including myself. They prepare a list. My position was 171. I am a UR category. So as per the reservation, because this 22.5 and 16.25 is the reservation for the SC/ST, and other posts are 61.25 is for the UR category. All these are the positions.
No, you are saying it is promotion.
Yes, promotion.
So it has to be roster point.
Yes, roster point. What happened, my lord? Roster points, vacancies were there for everybody. This 185% very well can be. But the defect here in this case is 185% sent to the DPC. DPC considered them, but DPC committed the mistake by violating that roster and all these things. Because the promotion is the basic jins, my lord, fall from the my lord's mouth. It is the roster points, my lord. The post-based reservation, we can say in this way.
Yes.
So there are posts. What they have done, the mistake is
they made it vacancy based.
Vacancy based and the seniority based. Because SC/ST persons, they were senior in the list, but they have recruited as SC/ST. So what they have done, seniority list, all these SC/ST candidates were placed first and occupy all the reserve category. So the reserve category, like me, my lord, I was at 171. We are pushed back. And by the time this reserve post, UR post were there, all these SC/ST filled up the post. All the vacancies are for the SC/ST, and we could not be accommodated there. This is the mistake they have done. Therefore, in one line, I would say the reservation should be on post base. And they have also admitted in their counter that they are not answering this aspect of the matter. What they are saying, as per the seniority we given them, because the SC/ST candidates were top of the list, they were observing the UR vacancies, and these persons are left.
So have you examined out of the 185 persons who were to be considered for promotion, how many had already got promotion as reserve category persons?
How
many?
All SC/ST or HST?
No, that's not the question. This is at the level of lowest rung of class 1.
Yes.
So those who are going to get promotion to this lowest rung of class 1, they are in class 2.
OTAS cadre, yes.
Class 2, superior grade.
Group B.
Just below that person. Let us assume that, let us not take the name, it's just below. So out of those persons, how many, because it is in group B class 2.
Yes, group B class 2.
Group B class, OTAS category.
OTAS.
How many of those persons belong to who have taken benefit of reservation in that particular case, level of employment?
My response submission is all these persons now given the promotion in the reserve from the reserve category, taken the benefit of reservation in their respective category. So therefore, there will be no quarrel between these two groups. If all of them will be accommodated, Only thing the post base.
There cannot be any quarrel. The reason being that it is not case of accelerated promotion. It is a filling up of roster point vacancy.
Yes. So
yes, Mr.
the
Behra.
vacancies are there.
So you have to show that you have followed the roster point.
That much better.
That is not there in the counter.
Then there is no point in filing a counter.
They count in only seniority.
There is no point in filing a counter.
There's
no
no
point
give
in
me one
filing.
opportunity so that I can,
No, definitely, because unless you say something, he is unable to answer also.
Yes, man, that part.
I mean, at least you must do that much for the petitioner who has come to court.
Yes,
that
sir.
let him know that he is not entitled.
My lord.
Mr. Samir Kumar Das for the petitioner, Mr. Prabhu Prasanna Behra. This is a very niche area of service law, this roster point, and you have to know what is the 80-point roster, what is the 60-point roster. And I am sure you will have develop a liking for this also. Once you work on it, it is actually mathematical. Actually mathematical. There are pigeonholes 1, 2, 3, 4, 5, 6, 7, 8, and the eligible persons. Now the question is that just only take one. Can be one angularity or one dimension where a scheduled caste person is topper.
Yes.
So he is not getting the benefit of the reservation.
Yes.
So for the entire career, he becomes the best person, the first person, and he also being the category in the scheduled caste, whether he can be kept out by another scheduled caste person who has a less merit. I hope you are getting it that way.
Yes, ma'am. Yes.
I have found so many people. They are ahead of SC and ST, but ahead of the UR category.
Yes, ma'am.
They are the topper.
Madam.
So they get selected. So reservation is lack of merit. Indra Sahni.
Yes. Yes.
You can, those persons who are getting on their merit in the UR category of 50%, their position cannot be counted as to be towards the reserve category.
Yes.
Suppose 1 to 50 is all are reserve category. You cannot give UR person beyond that because there is no reservation for unreserved category.
Yes.
There is no general reservation. So that part is to be carefully examined. That is what I was asking Mr. Das. Mr. Das is saying that whoever has got this benefit of reservation came in that category. They remain to be in that. Once one gets a reservation benefit at the entry level,
yes,
that he remains in that category for the his service life. Actually, will be considered, but he will not deprive a person of scheduled caste category who is higher up to him. Because then that becomes reverse discrimination. The person who is at top is discriminated by giving priority to a person at 10.
Yes.
That may happen, but you have to check that. Appearance Mr. Tarun Patnaik for the Public Service Commission. Mr. Tarun Patnaik for Public Service Commission. Had learned counsel for the petitioner. The opposite party number, the state opposite parties have filed their counter. Resender has been filed on behalf of the opposite party number 1.
Petition.
Has been filed by the petitioner in response to the counter. It is submitted by Mr. Patnaik, counsel for the OP number 3, that the OP number 3 being being a referral constitutional authority, their reply is not material for consideration. The reply of the state as well as the rejoinder being on record. Para. Mr. Das, learned counsel for the petitioner, submits that Departmental Promotion Committee was held on 27th February 2019 for considering promotion of the promotion to the post of Odisha Financial Service Class 1 from the feeder cadre of Odisha taxation and
This
quotas.
Taxation and account service.
Taxation and account service.
Yes, rules 2011.
50% of the 50% of the total number of posts in the promotional category of Odisha Financial Service Class 1 was to be filled up by method of promotion. Out of the 214, so that's 214 you said?
Yes, ma'am.
214 vacancies meant for promotional category. Only 11 posts were available, were filled up, and the rest, total number of posts.
198 vacancies.
198 vacancy.
Royal. I also fill up. 214 ru gale 14 216 ta fill up thila. Men in position thile.
214 ru men in position were 18.
16 jan thile.
Out of the
198.
out of the available vacancies.
Kindly turn to the DPC proceeding page 51, annexure 4. There they have stated all these things. I'm saying everything from record only.
Definitely.
Page 51.
Out of the 214 posts, the men in position were 16. The rest were remaining vacant. Such promotional posts in terms of the Odisha Reservation of Vacancy Act 1978, 75 and Rules 1982. Warby Act and
75 rule number 1.
Warby Act and Rules. Upon boyta ticket debe. Warby dakaro. This is a assignment of this court.
Yes.
This bench. Warby Act, TAS and Warby Rules. Achi se nale local act. Koi do.
84. 84.
Index to कौन नहीं स्वरूप बेटा उड़े थिला छाड़ो लिखो ठीक है पढ़ ले
से एससी एसटी मैनुअल टा उड़े
हाँ
84 से टूटा देखला
Warby Act dash and Warby rules dash blank Warby. It is submitted that the petitioner was at the serial number 171 in the combined gradation list of all the officers in the cadre of OTAS to be considered for promotion. He was legitimately expecting to be promoted to the cadre of the Odisha Financial Service in the class 1, into bracket class 1.
Junior branch 1.
Junior JB1. Junior branch 1. से पाइले नहीं बिल्कुल promotion.
ना अब 21 में सर पाई जाइए मैं 19 रू पाई
in the said DPC on held on date ता आपण देई छथि
27/2/19
27/2/19 and got the promotion only in the year 2021.
Yes, I'm giving you.
He's entitled to get promotion with effect from his juniors getting promotion
2019. Batchmates,
juniors and batchmates getting promotion
27/2/19
pursuant to the DPC held on 27/2/19. Perusal of the counter affidavit filed on behalf of the opposite party number 1 indicates that the aspect of roster point promotion and filling up of the promotional vacancies by applying the fixed roster point has not been dealt with. Learned AC fairly submits that in absence of the pleadings, he shall seek accommodation to obtain specific instruction. It is also expected, it is expected, the prayer is allowed how much time, Mr.
1 week.
As paid for list on 8/7/5/20/25.
Yes.
The learned AC shall obtain instruction with reference to filling up of the post as per the roster point for implementing the DPC on held on 27/2/2019. The instructions, if shall be filed in the form of an
affidavit.
the instruction be filed in the form of an supported by an affidavit,
Yes.
which the copy of which shall be served on the learned counsel for the petitioner and the learned counsel appearing for the OP number 3. On consent list on 8 8/5/2025. Yes, next. Aji achi lok. I have some other assignment. Yes. ମୁଁ ଦେଖିଥିଲି ଯେ ଟକ୍ସି ଟେବୁଲ ଉପରେ but somehow ମତେ ଲାଗିଲା out.
Item.
He will call page wise. Any adjournments he will when consent the dates on consent. You please tell him the court master he will give you. I will only dictate the mentioned matters. Orders will be in the mentioned matters. Page 4 ଆପଣ କୋ page 3 ଯାଇଛନ୍ତି?
21 22 ଯାଇଛି। 21 22
22 ଗଲା। ବର୍ତ୍ତମାନ ଆମେ କୋଉଟା କରୁଥିଲେ?
ନା ଗଲ 20
20
21 22 ଯାଇଛି।
21 22 अच्छा से मेंशन करथिले। हां प्रशांत आपण प्रफुल्ल बाबू। Then page 5 ताले page 5 डाकंतु
page 4 रो 23 ରୁ 25
सेटा से आपण डेट देबे। After 4:15 I am not taking up any matter. I have some assignment actually. So only those matters which have been mentioned.
28 next week.
Yes. All matters are not going out of list. Any adjournments or accommodations, he will give you the date. Please inform him. He will work it out. Yes, Mr. Kanungo.
Item 32 is fine. 32.
Item 32.
Yes, Malad.
So kindly wait. I'm getting there. Because there are the item 29 and 30 have been mentioned. So he's just calling the list. Just give us a moment.
Malad. I'm sorry.
Dakon 29 dakon tu.
29
Mr. S.S. Patnaik for the petitioner. Ki astile tanka pai?
SS Patnaik
Pratik Das ko pe ajon ki thile ta na double likhini. Mr. Pratik Das for the opposite party. The learned counsel 6 for counsel for the petitioner 6 accommodation for matter to be posted to after vacation. The learned counsel for the opposite party submits that the matter may be listed before vacation.
14
List on 14/5/2025. Next.
Item 30.
Mr. S. Sekhar for the petitioner. The learned counsel for the petitioner 6 accommodation as the service of notice has not been sufficient on the opposite party. Registry shall place on record the updated the registry shall place on record the updated postal tracking report and also verify if service return is available. Yes, next page. Interim order to continue. Interim order dated so and so. A list on 13/5/2025.
Item 40. 39.
49. Mr. Kanungo.
32, my lords.
Yes.
This is a certificate case initiated which is wholly without jurisdiction because the department.
So you want it to be taken up?
Yes, if your lordship.
So you give a date. He will give you a date.
Any date subject to your lordship's convenience.
No. I'm giving any date you want. It will be given. But you please suggest a date. It will be easier for him to mark it.
Tomorrow, day after, or maybe on Tuesday.
Tuesday hoji kete tarikh? On 29th.
29th.
32 kar debe due to paucity of time the matter could not reach mentioned by the learned senior counsel Mr. Kanungo. On consent list on 32 state council ki ache Mr. Anshuman Sethi. Yes. On consent list on 29 4 20 25 मिस्टर बारिक आपण ए जो गुडाक आजिकर अछि आपण जदि मंगलवार तक आउर तळकु नै जिवे केमते हो एटलीस्ट दे शुड रिटेन द पोजीशन आपण जे 22 जाय नै गले ना 22 पर 8टा मैटर रहला आपण जदि सेदिन भी तक करियो 40 डोंट डू दैट
लेफ्ट ओवर हे आसले
लेफ्ट ओवर रे की ता काली कास जो टुमोरो जति रहउ त
काली हला टुमारो इज ओके विथ अस
ठीक अछि रखो
oblige
but tomorrow there is a notification for I think reference already so let it be since you are saying about urgency let it come on that day it would be better so at least if in the leftover it will come on the next date
left over next day
yes so to 29th Mr. City yes
oblige
any other mention
because tomorrow
Sir?
I may not be
Item 33. Tomorrow I may not be available.
No, 33 I'm not taking all matters I'm not even if tomorrow don't worry about the adjournment if it is listed I am saying any learned counsel requesting for any adjournment or any date please let him know or else he will place it as leftover that's a different thing but leftover the difficulty is that tomorrow we will not be having the full day
interim order may continue with the
so if it is not reached no difficulty
30
yes thank you
oblige